is capturing the imagination of different members in advance in case I want to discourage or whatever. Yeah.
Every 8 or 10 years.
Mics are live.
Oh. Okay.
You have to call us to order.
What time is it?
It is 1:30.
Everybody ready? Welcome to the February meeting of the Rehoboth Beach Board of Adjustment. Roll call. Bill Pearlstein.
Here.
Edie Heron. Here. Mark Saunders.
Here.
Jan Conacy is here. Barry Brandt is not here today. So we have a quorum, and we will continue with our hearings. Was the meeting and public notice properly posted, and did we receive any, well, I know we received correspondence regarding the case today. Ann, do we have any more that we didn't get in our packets?
No.
Okay. We have minutes from previous boards that we need to review and approve. Edie, do you want to?
I move that we approve the minutes of September 26th. And can I do them, both of them in one motion? Or one by, is it better to do?
You can do
is it better
them
to do-
both, but if any of the members wanted to question the minutes from either of the meetings, then we could separate them.
Okay.
Okay.
I move that we accept the September minutes.
Seconded.
Do we do a roll call vote on minutes?
You can say all in favor.
Okay, all in favor?
Aye.
Any opposed? Okay, thank you, unanimous. And I think we have another set of minutes, too.
And the November.
We do. Well, I'll move again. I move that we accept the November 27th minutes as written.
Second.
All in favor?
Aye.
Aye. Passed unanimously. Ann, is there any old business? No. New business. And we have, I'm going to review the criteria for applications for variances. Under Delaware law, an applicant for an area variance must prove that the requirements create an exceptional practical difficulty. To determine whether an exceptional practical difficulty exists, the board must weigh the following four factors: the nature of the zone where the property lies, our rules, oh gosh. I'm sorry, I apologize. Yeah, no, I know, but I messed up my papers, and I'm, no. There's more than that. Can you, Fred, continue with the rest of it?
I can. So
Thank
the considerations for the board are firstly, as Ms. Conacy pointed out, an analysis of the nature of the zoning district in which the property lies. Secondly, what is the character and uses in the immediate vicinity? That's our second consideration. Our third consideration is whether removal of the restriction on the applicant's property would seriously affect neighboring properties. And lastly, whether failure to remove the restriction creates an exceptional practical difficulty for the owner in relation to the owner's efforts to make normal improvements to the property. Those are your four considerations. The fourth consideration I'll add is where you ask whether the applicant is seeking more relief than they actually need to relieve their asserted difficulty. And then I'll also take this opportunity to say that it is somewhat unusual for this board to hear appeals from determinations made by the building official. I'm going to read to you what your jurisdiction is in these instances. In addition to deciding whether to relax the strict enforcement of any zoning criteria, this board is also authorized to hear and decide appeals where it's alleged that there's an error in any order, requirement, decision, or determination made by the building inspector in the enforcement of this chapter or any ordinance supplemental hereof. So what you don't hear there is that the standard of review requires you to give particular deference to the building official. And Mr. Pearlstein, as a lawyer, you encounter, I'm sure, on appeals from time to time, questions where the lower court is entitled to some deference by the appeals court. And that's not the case here. So what you are essentially doing is substituting your collective judgment for the judgment of the building official. That's obviously meant to be a neutral statement. It's just a statement of fact that this board substitutes its judgment for the judgment of the building official. Okay? Any
thank
questions about that?
Thank you, Fred. And I found my place in my notes again, so if you'll bear with me, folks. And I had one more question for you. Our rules require that owners of property within 200 feet of the property in question get notice of the variance request. Did all property owners within 200 feet receive the notice, and was the Board of Adjustment sign properly displayed at the property?
Yes.
Thank you. Finally, after the applicant and the public finish speaking, we will close the public part of the meeting, and no further comments will be heard as the board discusses the case. So the process will be a presentation from the city, board questions to the city. That would be the building inspector. Presentations from the applicant, board questions to the applicant, people wishing to speak for or against the variance, closure of the public commentary, and discussion among the board motion, and board vote.
I have a question for Fred. Are we looking at the appeal as a one train car, close it off, and then looking at the variance separately in both of these cases? Because each one is an appeal and then a variance.
Right.
Are they to get, are we looking at, how are we looking at them, please? If you could clarify.
So you have flexibility, but what you would typically see in a case like this would be you would address the appeal first, because the appeal would, if granted, would obviate the need to hear the variance application in both cases. Now, it could also be the case that the board could hear the appeal first, deliberate, and then defer action on the appeal, and then move into the variance, and then finally move either on the variance or on the appeal. If the variance were granted in that instance, then the appeal would not need to be
moot.
heard. If the variance were denied, you would have to, you've got to address the appeal.
I see. Thank you. And Dan, I remember, I noticed we didn't introduce Fred. Should we have? I'm sorry, I said we didn't introduce Fred at the beginning when we took a roll.
Just for the record, Fred Townsend, Hudson Jones, Jaywork, and Fisher, I'm the attorney for the board. Thank you, Ms. Herron.
You're welcome. Sorry, Ann, I will keep my lips right by the mic.
Okay.
Thank you.
As we don't have a court reporter present today, if a transcript of this hearing is ever required, the court reporter will have to work from the tape recording of this minutes, which then says, keep your voices up, speak into the microphone, and no cross-conversation during the hearing. If at any time the technical team or any board member feel that we are not getting an accurate recording, we will stop and remind the speaker. And I assure you that Ann will do that. I'm going to start with Corey. Are we doing, one more thing. No new letters came in since the ones, okay,
No, do you want me to do the verification?
sure.
The agenda was posted in City Hall and on the city portal on February 15th. The agenda notice was sent out from the city portal on the same day. The agenda was amended and reposted on February 20th and 21st. The public notice for case number 0124-01 for the property located at 347 Hickman Street was posted in City Hall and on the city portal on February 1st. The public notice was published in the Cape Gazette on February 6th and February 9th, and Delaware State News on February 7th and February 9th. Notification specific to this case was mailed out to property owner addresses within 200 feet of the subject property, and signage was posted on the property. The public notice for case number 0124-02 for the property located at 204 Philadelphia Street was posted in City Hall and on the city portal on February 1st. The public notice was published in the Cape Gazette on February 6th and February 9th, and Delaware State News on February 7th and February 9th. Notification specific to this case was mailed out to the property owner addresses within 200 feet of the subject property, and signage was posted on the property. That's all I have.
Thank you, Ann. The first case that we're going to hear today is on Hickman Street, 347 Hickman. We'll start with the building inspector's report. You're not the building inspector.
Okay.
But you will come up to the table when it's your turn. Okay, okay. That's all right.
Good afternoon, members of the Board of Adjustment and the public. My name is Corey Schinko. I'm the building inspector for the city of Rehoboth Beach. This is the building inspector's report dated and signed February 12th, 2024. This is for case number 0124-01 at location 347 Hickman Street, Rehoboth Beach, Delaware, 19971. Tax map parcel number 334-19.08-53.00. The applicants are Pamela M. Kaplan Revocable Trust with Robert N. Kaplan Trustee at 9 Summerfields Court, Lutherville, Maryland, 21093. The owners are the same. The subject, there are two. The applicant seeks appeal of the decision of the building inspector for City Code 270-21A natural area. The applicant also seeks a request for variance for City Code 270-26A side yards and 270-82 enforcement of chapter plot plan. The nature of request. The applicant is seeking, one, an appeal of the decision of the building inspector for zoning chapter 270-21 natural area, and two, a variance to City Code section 270-26A side yards in conjunction with a determination that the existing accessory structure is legally nonconforming. The purpose of the application is to allow for the continuation of an existing side yard patio and its encroachment into the minimum 6-foot setback, as well as the construction of 167 square feet of walkways. The property is located at 347 Hickman Street, Rehoboth Beach, Delaware, 19971, and is situated in the R1 residential district. The property is a 50 by 100-foot lot with an existing primary dwelling and an existing accessory building. The application background and information. According to Sussex County property records, the one-story single-family dwelling was purchased by applicant on July 29, 2002. The applicant seeks to appeal the decision of the building inspector to allow for sidewalks on the property, thereby reducing the natural area. The applicant also seeks a variance to permit the continued existence of an unpermitted patio within the required side yard setback. The survey dated July 16, 2002, provided by the applicant, does not contain any depiction of the side patio. During plan review, no evidence could be located in city records that documented a side patio. The appeal of the building inspector requested. The applicant is seeking an appeal of the building inspector's decision. Read the following provisions. City Code 270-21 natural area A, that states, in R1S, R1, and R2 districts, a minimum of 50% of the gross lot area and 50% of the front yard setback area of every building lot shall remain as natural area as defined in 270-4. Per building inspector's Exhibit A, natural area was calculated at 2,521 square feet. Any sidewalk installation of more than 21 square feet would decrease the required minimum natural area 50%, or 2,500 square feet. Per correspondence dated December 29, 2023, titled 347 Hickman Paver Walkways Review, corrective action was detailed as follows. Patio must be either removed or retroactively applied for, and no part of patio may extend within 6 foot of side property line. Lot coverage calculation for additional 3 walkways, those applied for, must show the natural area of the property is not less than 2,500 square feet, 50%. End quote. Although sidewalks are expressly excluded from the definition of structure, they are not natural area either. The variance is requested. The applicants are seeking relief from the following provisions. City Code 270-26 side yards. Letter A, 2 side yards shall be provided on every lot as prescribed in the following table. District and use R1, minimum width 6 feet, minimum aggregate 16 feet. 270-82, enforcement of chapter and plot plan. The building inspector shall enforce the provisions of this chapter. The building inspector shall require that the application for a building permit and the accompanying plot plan shall be submitted in paper form and in digital format acceptable to the city, and shall contain all of the information necessary to enable him to ascertain whether the proposed building or structure complies with the provisions of this chapter. Per correspondence dated December 29th, 2023, titled 347 Hickman Paver Walkways Review, quote, "The property was found to be in violation of the following codes," parentheses, see attachment for additional comments. Number 1, work performed without a permit. Letter A, roughly 381 square foot patio installed with no record in city files. Number 2, patio encroaches into the 6-foot side yard setback. Number 3, due to unpermitted patio, the property's lot coverage exceeds allowable limit of 40%. End quote. A thorough search of city records yielded no documentation of a patio ever recorded. Per correspondence dated January 3rd, 2023, titled Forward 347 Hickman Paver Walkways Review, a request to ascertain if the applicant had documentation providing evidence that the city had recorded the patio was provided. Start quote, "If you have any documentation of the patio on record with the city, please send that to me and I will take that into consideration. I could not find any record of it in the property file," end quote. Pursuant to the above zoning code sections, if a property owner fails to secure a building permit or Board of Adjustment certificate previous to the construction of a structure, it is recognized as a violation of the zoning chapter. Conclusion. The addition of new sidewalks would violate minimum natural area requirements, thus was denied by the building inspector. The construction of the patio was performed without a permit or Board of Adjustment certificate, thus creating zoning violations. End of report.
Corey, one thing, I believe you meant January 3rd to 2024, the third to the bottom paragraph on the second page. It was correspondence dated January 3rd, 2024, right? It was more recent than a year and
Yes,
some ago.
my apology, that should be 2024.
I just want to make sure we're square on the record then. Thank you, that was all I had at this point.
All right, thanks, Corey, for your presentation. Are there any questions that anybody has for the building inspector?
I have one, if I may. Corey, can you tell us what year I'm sorry, in regard to the offending patio, the existing patio, what year would our ordinance have gone into effect that would have been grandfathered?
That, I'm not sure when that would have been grandfathered in. The 6 foot came into play, I believe, in when the pool ordinance.
That was
That was the rear yard
2016.
setback,
No,
excuse me.
no, I'm sorry, that's not right.
I don't know the answer to that question off the top of my head.
Actually, we've had 6-foot side yard setbacks for a long time. It's the 16-foot that came in.
The aggregate.
The aggregate, it was aggregate 12, and then the 16, then aggregate 16 came in, and that was to allow for trees, so that if you had a tree, that you could have a higher setback on one side to save the tree on the other side, but with a minimum of 6 feet. And I've been in Rehoboth for more years than I care to count, and it's been 6 foot at least since the early 2000s, if not before that.
And to that question too, when it comes to structures that I find in plan review that have no documentation of ever being permitted or recorded, for that matter, in city record, I only ever hold them to the current zoning codes, if they were to have to retroactively apply for those structures.
So, Mark, I just will add, in that case, when that house was built in Country Club, they were probably 6 foot on each side. And so, you know, that would, to me, would be what, you know, is reasonable for that, but that's still, it's still, intrudes in that 6 foot even.
Exhibit A, Corey, says it's, that the plans were received in July of 2021, attached to your report.
What page are you on?
Right there.
Oh,
Oh, That's actually, this was a survey that was used for a previous tree permit that was done in 2021. So the comments that were made on this survey were overlaid on top of the only survey that I could find in city record, and that came from a tree permit from July 2nd, 2021. And that's why there's a yellow highlighter mark there that says holly tree on it.
I understand, but the red existing patio language, was that put on in 2021 or more recently?
No, anything in color that you see with red or blue, and the green as well, that was all put on for this application.
Right, right. As I understand it, Corey, the page 21 of, well, you wouldn't have it, maybe all of that, but the it's written as is in the upper left corner, handwritten as is. There's a is it Wingate? Yeah, a Wingate survey. And it's dated
Where I was going, Edie, was, I'm trying to understand, they submitted the tree survey in 2021. It showed the patio. And my question to Corey was that flagged for them in 2021 that it was a problem? And if not, you just said that if you see something on it that's problematic, you let people know that. And that's really where I was going with my question.
That's a good point. And yes, you're correct, but that's only when it would go to a building inspector for zoning review. This particular, when the survey came in for the particular application, it was for a tree. So the only review that would have been done along the lines of this survey would have been for that holly tree.
Okay,
So
And it wouldn't have been done by the building inspector.
that would have been done by the
arborist.
arborist.
okay.
right, and the Parks and Shade Tree would have dealt with it.
That's-
The Parks and Shade
yes,
Tree
ma'am.
Commission would have dealt with it had it been needed to go to one of the commissions,
That's correct.
if the arborist couldn't handle it, right. So the survey that we have, the Wingate, that dated 16 July 2002, that is labeled as is in the upper left corner, is how it looked in 2002 as far as Wingate was concerned.
That's correct, and that seems to parallel when the deed was transferred from
Right,
Sussex
right,
County Property
because-
Records.
Right, it was with the 29th or 27th or something, just within 2 weeks, the sale was completed. So this must have been a portion of the sale documentation. So I have a question for Corey. Is it true that since we have 2521, I'm sorry, 2521 area, natural area available at this point, correct?
That's correct.
Okay.
That's-
Now, if we just pretend we don't have the patio for a moment, that's 381 square feet in addition. So that gives 2,902 square feet to work with. Of that, 2,500 square feet has to be designated to natural area. So that leaves 402, the difference between 2,500 and 2,902, 402 square feet that the applicant or owners may use in some form to cover property, walkways, patio, whatever. Am I saying something that's correct?
That's correct.
Okay, so, but we're not ever designating how they use that. They can decide that. But they have 402 square feet to deal with, to add their walkways, because I noticed there was a previous application for walkways that was 245 square feet total. Now they've gone down to 167 feet total. Is that correct, 167?
Correct.
Okay, so they have 402 square feet of natural area. Again, pretending that current patio is not there. I'm not saying anything about whether it should go or not. I'm just saying it's a piece of land, and so they have that amount of square footage to determine how they might use it and still be code compliant for natural area in the city.
That's correct.
Okay, I just want to make sure I'm understanding.
I have to use kind of an asterisk here because
Okay.
the numbers that I arrived at here, I have a Blue Beam program, and what that allows me to do is to take a survey like this and to scale it and then use that scale to get the best estimate that I can with the program that I have for the number. So there's some tolerances there, but if anything were to come for lot coverages in the future, an actual final as-built survey would be required at final inspection. So it would be stamped off by PLS
Okay.
that the city would be able to verify.
I understand, thank you. You're just saying there's wiggle room in the numbers, just a little bit.
there-
But
there always
we're-
is.
But the broad
Roughly.
concept is
Yes, ma'am.
is factual. Okay, thank you. That's all that I have right now. Bill, did I interrupt you in
No,
what you
I'm
were
fine, thank you.
saying?
One question, Corey. Looking at there are two driveways. The driveway to the left, I mean, there's two driveways on the property.
Yes.
But property, there's a small walkway, sort of looks like a ramp almost, that goes to the side door. Have you considered that as a permanent fixture, or is that just a temporary ramp? In other words, was that figured into the coverage?
How I put that in
have that
this
little blue
in this
here.
zoning here was a walkway. As long as, if it's not serving the front entry, we go under the definition of the definition of sidewalk. And so if it's usually 3 feet, no wider than 3 feet, and its primary function is to be used for pedestrian travel, then I usually put that as a walkway, as its only use and function is to provide access from the driveway to an entry.
I thought it almost looked like a handicap ramp almost, and that's why I was wondering if you had considered it in or not.
Under this zoning, how I've considered it as, it's under blue, and I highlight that because sidewalks and driveways in the last part of the definition of structure are not included as structure. But they're also not natural area. So they go against natural area, but they're not included in the 40% structural lot coverage.
I gotcha. Thank you very much.
Does anyone else have any questions for Corey?
And just real quick, if this board were to legalize any of these conditions which the board determined to be not legal, non-conforming, you would like there to be a condition that the applicant would be required to submit a building permit application? I presume, is that?
Yes.
Yes.
That's correct.
But, and that would require the payment of a fee, I presume. But you would not, I don't think you would be required, or you would have the flexibility to deny that permit, right? It's just papering the file? Is that what
I'd like to understand the question. Is it that if nothing were to change and no new construction was to be sought,
Well,
only
if
to have
an-
these?
Well, if any of the conditions that exist right now were legalized by the board through the granting of a variance, and I realize we're not at the variance stage, we've got an appeal and we've got a variance, but if the board grants a variance to allow any of the structure to remain that that the building inspector deems to be non-compliant with the code and illegal because it didn't pre-exist the code, you would like to see a building permit as a condition of the approval.
That's correct. Going back to the 270-82, the enforcement of the chapter with the plot plan. We would need to get something given to the city, have the variance attached to it to show the conditions, and then we could put that into the official records in the
So you would
archives.
accept the fee,
would be
presuming
a-
the application was complete, you would grant the,
A permit for the patio?
you would grant the permit, I presume. You wouldn't have the discretion to deny the permit after the board were to grant a variance if they chose to do it.
Correct. The only thing I would require is that an on-site inspection to make sure that upon completion of processing and archiving that permit, that the site conditions matched what was on the variance.
Well, we don't want to get into a situation where we all in this room grant something, if it gets granted, ultimately, and then we find through a site inspection that we have granted 85% of what's required to legalize it, which would not resolve the issue. Again, I don't know if this board's going to grant any variances, but if it does, it'd be my hope that it puts to bed the issue that we're confronted with.
Okay. Following up on that, I guess I have a question, and that is, does the current patio, which is not allowed, I mean, it was put in without a permit at some point, does the current patio meet the requirements that we have today for constructing a patio?
Zoning-wise?
Not zoning-wise, construction-wise. I mean, do we have, I don't know, I've never built a patio, so do we have rules about how a patio should be built? It has to be so thick or so this, a slope, anything like that. Does that patio currently meet any of the requirements that we have for constructing a patio today, assuming that it had a building permit at one time?
Sure. There's best practices when it comes to these. I believe this is
Right.
a ground level stone patio. The only thing when it comes to that I would check as far as construction, from a construction viewpoint, is that there's no tripping hazards on it, and really that the grade hasn't been brought up so much that it would cause negative stormwater to the neighboring properties.
And I think we'll find too that this is being rebuilt right now, which is what brought this to the head. right?
Oh,
Isn't
without a
that-
permit? Is that what happened?
Not to
There's
my
the
knowledge.
big-
I-
What are the big piles of stone that are in front there?
That would be to ask.
Yeah,
Yeah, I can't
that's-
answer that. What I
that's
can
different.
answer is that the
Perhaps-
application,
Talk over each other.
Okay, sorry.
Go ahead, Corey.
all I can speak to is the application that originally came in that started this was not for the patio, was for proposed walkways.
Maybe that's it then, right?
yeah.
We'll find out when we talk to the Kaplans. I guess. Thank you.
Any more questions for the building inspector? Okay. Does the applicant want? Okay, and you have to be sworn in, Mr. Kaplan, to testify?
So you can have a seat, I'll swear you.
Okay, swear me in.
So what you typically do is you give us your name for the record
Okay.
and your address.
Robert Kaplan, local address is 347 Hickman Street. You need my home address?
You can give it if you like.
9 Summerfield Court, Lutherville, Maryland.
And Mr. Kaplan, do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, you may proceed.
Thank you. So I'm just, offhand, I don't have any dispute or concerns about the measurement. I think the story was told about the setback. The situation at hand is that patio has been there ever since we purchased the house, which was in 2002. Appeared to be an older patio at that time as well, and it's a concrete patio. And if you look at the house, it looks like it's always been there. I have no knowledge of when it was put in, only could assume it was put in the 70s when the house was purchased. And the city doesn't have any permit information. I don't have any permit information. I don't think anyone can really tell the date that permit was put in, whether it was done correctly, not correctly. There's just no knowledge at this point in time. What we did, and it's disappointing, is I did, assuming it was an existing patio that conformed, and as I said, I have no knowledge, it wasn't written up as non-conforming in my title work as well. Those stones were laid on top of the patio. They can easily be removed, but they were laid on top of the concrete patio because it was cracked and very old.
When were they laid on top?
Pardon?
When were the stones laid on top?
Because the patio.
When?
Oh, August probably
Of this year?
of 23.
Okay. And you never got a building permit for that?
No, just because it was like-kind replacement.
Okay.
And nothing was changing dimension-wise or anything of that nature. Nor is anything changing dimension-wise at this time. So, if I look at the survey, I actually have a bigger problem. My house sits in the setback too. It only has 5 feet 8 clearance, not 6 foot clearance. So that's problematic. And I do I have to amend the variance to incorporate that I want to keep my house up?
No, you don't have to do that.
Okay. To answer your questions, on the other side of the house with the door going into the kitchen, which has always been there, there's a step, and it's just a decking that could easily be lifted up at any point in time. It's just to get over the mud that forms there when the water rains, but can be picked up. It's a temporary type structure. Are those steps in violation because they're in the 6-foot encroachment area?
Probably now they are, but it doesn't matter. That's not
Okay.
what we're here to talk about.
All right.
Do you want to say?
I'd be happy to answer. The survey that came in that the city had a record of, anything that was shown there, I included as legal existing non-conforming. It was only because the patio didn't show up on the survey.
Okay.
That was the only difference between any other structure on the survey.
Understood then. So the patio would be in question. It's been there either from 1978, it came in existence between, I think, 1978 when the house was completed and 2002 when we purchased the house. And has always been there. And we've applied for permits in the past. It's never been brought up. Fence, we did some interior work and restructuring, and it's never become an issue until this point.
Does anyone have any questions for Mr. Kaplan?
Just for full disclosure, I've never met Mr. and Mrs. Kaplan before in my life, but I walk by your house every day with my dog, and I can testify that the original patio has been there at least 15 years that I've been walking by, so,
Okay.
for the record.
So may I ask, are you amending your petition for a variance in that you're not requesting to add additional lot coverage, or you still are requesting to make?
I meant the original request had 3 walkways,
245
and now we've reduced it down to 167. One of the walkways would have been within that 6-foot setback, and that's the one I took out of the original request. So it has been amended.
And you realize what we talked about, the temporary, I call it a temporary, you called it a wooden plank or something? to go
Yes.
From the side door to the front, is being held against you, so to speak, as square footage. Would you be willing to give that piece up in order to get one that goes from the driveway to the front door?
No,
It's not being held against.
no, it's not.
It's being held as part of the coverage.
No, that's
I
not.
thought Corey said it was.
No.
Well, in a way, you're correct. Any coverage, whether it be structure or sidewalk or driveway, does reduce the amount of natural area.
Right.
However, it's in blue because it's not being seen as structural coverage.
All right, so you're not
So the
coming-
when it comes to lot coverages, you can max out at 40% for structure, which would be anything in red on that survey. You don't have to. You can do 35%. And then the remaining of that, which would be 15%, that would get you from 35 to 50, could be used as walkways, sidewalks, or driveway. The driveways and sidewalks can fluctuate. They don't have to just be 10%. They can be more. It's just so long as the structural coverage doesn't exceed 40% and the natural area is at least 50%.
I'm with you. All right, thank you.
Okay. So the 2 sidewalks that I'm requesting go to the front door, and then one from the rear to the back of that patio to an outdoor shower.
Right.
Right.
All righty.
As you looked at options for solving what you wanted to do, from what I understand, your primary first thought was, we'd like to build some sidewalks or walkways, whichever you call them. I've seen them referred to in both ways
Right.
in this documentation. So you wanted to build some walkways. And so you had the 245 square feet idea, and then when you found there was a little throwback from that or whatever, you decided you'd go with the 167.
Correct. When I found out it was in the 6-foot area and I exceeded the amount, I said, all right, we can forego that sidewalk along the side of the house from the driveway pad to the patio. We don't need that, and that's why I took that out. That was
But
just,
when you found out that the patio at 381 square feet was in the side yard setback, did you give any thought to what if we went with a smaller patio and we were within we didn't go into the side yard setback, and that would also give us a few more square feet of latitude for the natural area? I'm
no,
asking,
that's a good question.
I mean, what,
The question,
what are the options?
My response naturally is that patio has been there since, as far as we know, whenever. So it would be a considerably different project than what I had originally intended, because that would ultimately require digging up the entire patio and relaying a new patio. Not that, in theory, could someone cut 6 feet off it, but it just wouldn't look, the way it would hit the house and everything wouldn't be aesthetically pleasing. It would just end. So I was trying to use the existing base that was always there, to my knowledge, I assumed approved at some point, and just use what, resurface and make it more appealing visually than redoing the entire patio.
and you probably know one of the driving forces of the natural area is for water absorption.
Correct.
For the citywide. I mean, that's the baseline reason, all pun intended, to let the water not to have enough space for it to dissipate properly, and that does the entire community good. That we don't have overpaved, overcovered, which is why we have the natural area.
I think there's plenty of houses that exceed that, than what I have.
We can only take a case one by one.
I know, I understand,
And
right.
there are no precedents that we look at. We don't look at any precedents. We're looking at each case on its own merits. And we also are looking at the land, not the people. And I don't know if you're aware of that. Because if we grant a variance, we're saying, and ad infinitum, this land has this kind of ability to be built in this way or left in this way.
Correct.
No matter who's there, whether it's owners or renters or whoever it is doing whatever. So we are our view is a little bit different than you might expect, but I always try to make sure that people understand that we're not.
No, I understand. I appreciate what point how you view it. I mean, that's what you're supposed to do, right?
We have to, because we're
Correct.
talking about the land, and you could sell it tomorrow, and whatever not that you're going to, I'm saying, and whatever we granted for it would go to whoever, to whoever, to whoever, to whoever.
Right.
So I don't have anything else.
Does anyone else have any questions?
Okay, so I would like to, may I?
No, you may,
Okay.
absolutely.
So I didn't know if you had a few questions that you wanted to ask.
I will ask, but I'll wait for you.
Okay, well, what I'd like to do at this point, and I recognize, and the board recognizes, that you're not represented by counsel, so we're kind of mixing the appeal and the variance presentations together. But what I'd like to do is ask you to try and focus on the appeal that you filed and ask or present to the best of your ability what it is that you feel the building inspector erred in interpreting or erred in his judgment that has adversely impacted you.
And I'll be nice. No. I don't think the building inspector, Corey, really erred in his interpretation of the rules. I don't disagree with his calculations. I don't disagree with what he did. I would say the error was in his collective judgment for the request and the situation at hand. The square footage, the patio, I mean, you sort of have to keep the patio in there because it falls within the numbers for the natural coverage. It is always been there, to my knowledge. And then I, would like to think you could have a front walkway to your home. Right now, I have stairs that go to grass with the front door that was permitted and approved. And the walkway to the outdoor shower would be nice, that you don't have to track mud and dirt on your feet. And we've been doing that for 20-some years, and it was great when we had young sons, but now that we're a little older and a little less, we're a little fussier about the amount of dirt that comes in the house. So I would say it was a error in judgment, which is the basis of my appeal.
Is that to say that the building official shouldn't have considered the existing walkway in determining whether to approve your application, or not walkway, existing patio in determining whether to approve your application for the 2 requested walkways?
I would say, because that was something that it's been there. I mean, it's, whatever, you can't change, you can't put the milk back in the bottle.
Okay. So could we hear from the city in response to that position, please?
Thank you, and good afternoon, everyone. My name is Alex Burns. It's a pleasure to be here, members of the public. I think, one of the easiest ways to think about this is that, natural area has a specific definition in 270-4. And sidewalks cannot be natural area. And at the same time, sidewalks are not structure. So they're not structure, they're not natural area, there's what's left. And at the end of the day, the natural area requirement is a minimum of 50% natural area, and that's being violated here, and that is why we're here today.
So is it relevant that in your estimation, that the patio has been in existence for a long period of time in making the determination that additional coverage is not permitted by your lot coverage restriction?
Yeah, as Corey mentioned, we're not exactly sure when the patio was constructed, but yes.
Can I ask a quick question? No.
I don't know, does that generate any questions?
Yeah, I'm trying to understand what the issue is. Where I thought you were going with your last question to Alex was, does it matter at all whether the patio had been previously approved or not? And this is basically a mathematical
That's right.
calculation. And so to the applicant, even if it had been fully approved, even if it had been clear on the 2002 survey and all that, you're still over the percentage. So as a legal matter, I don't understand what the appeal is, because 50% is 50%. I don't believe that they're saying to you that the denial on that they're not saying you need a variance for the walkways because there's a dispute about the patio. Even if there were no dispute about the patio, you can't have more than 50% coverage, period, without a variance. Is that a fair?
That was where I was going, yes, thank you.
So I don't understand where, and I know you're not a lawyer, and
Right.
That's really
And
fine.
I'm glad.
But I don't see that there's a legal appeal here, an interpretation appeal here. It's really a variance issue solely from what I can see on this particular issue.
The way I understand it, the only way we would grant the appeal is if we feel that Corey made an error, excuse me, an error in his calculations. That's what I'm
Yeah, or if
understanding.
there were a dispute between whether this was a structure or coverage or not, and that also does not seem to be what the issue is here.
For the appeal,
Yes.
for the appeal, we're
Yes.
talking just about the
I just
appeal.
have one more question for Corey. There are 2 driveways. Okay, is that correct? I mean, they look like it from the road.
There are 2 driveways.
Okay, so are they, what's required, or to have 2 driveways? I mean, my observation is, aren't they long and narrow or short and fat,
Well, the survey that was marked up in plan review only encapsulates one driveway,
Is that the one on the
in the
west
blue on the
side?
left side.
Yeah. So there's this, so this space is counted as natural area, which looks from the road like a driveway on the east side,
If,
in the front.
if that's the case, the driveway and walkways right now are at 5%. That would take away additional from the natural area. When I had done this review, I was going only with the interpretation of the one driveway, not two. That wouldn't count against lot coverage in red, but that would add additional coverage in blue, thus taking the natural area down further.
Farther. Okay, I have a question for Fred then. Do we vote on whether to grant the appeal and then move on to the variance? Is there a process?
The process, there is a process, and we are going to deal with the appeal first. We do have to ask. I think we should give the applicant one more opportunity to address what's been said since the last set of questions was put to the city. We do need to ask if anyone is here, and a show of hands would be fine, who wishes to speak on this application, but only on the appeal aspect of it, because you'll be invited, if you want to speak on the variance aspect of it, to come to the podium later.
You
All right.
have to get sworn in if you want to talk.
Oh, okay.
But I have a question first. I mean,
So, one second. So we're going to allow for public testimony, and it looks like we have one person who wishes to speak, perhaps on the appeal, perhaps on the variance, perhaps on both. Mr. Kaplan, do you have anything else you
I
want
do
to
have a
add?
question, just to make sure we're looking at, in my mind, looking at things right. When did the natural area requirement go into effect?
Do you remember when? I mean, it was either 40 or 50% as long as I can remember. I mean, it was 40 and then went to 50 or something, but I don't remember
And
exactly.
in answering that question, could you also speak to what the significance, legal significance of that would be? So that if the city were to concede somehow that the patio that was installed perhaps prior to the adoption of restrictions against lot coverage, would the city then conclude that we don't have to count lot coverage that existed before the lot coverage restriction was adopted? Because I think that's where the applicant is going with their question.
If it was found that the city had permitted and we had a record of any structures on a parcel, and we would have to have record of them in order for them to be seen as such, it's kind of a capsule in a time freeze there. It was allowed to be built at that time. Whatever codes allowed it to be built at that time, whether we were in CABO back in the 90s or if it was built in the 70s or 60s, we take that into account. But again, it's only for structure. We only legally non-conform structure. We don't legally non-conform the symptom that comes from the structures, which is then the setback intrusions or the lot coverages or the building heights. Those come downstream of the structures. So if we did find, for instance, that the patio had been recorded and we had it documented and it was done at a time where they could have 40%, let's just say for argument's sake, natural area, then that would be fine. They could keep it. They could make repairs up to 50% of the structures, and they can continue on ad infinity with those structures. But if they were to ever add new structures, anything new, whether it be an addition, a new structure, a second story, all has to conform to the zoning codes that we operate with today.
Yeah, so isn't the issue that the applicant agrees he wants to add to the coverage over what it is today? And so, since what I understand what Corey is saying, that, they then need to, if they're going over what the code is today, that they then need a variance. So if they had, let's say they'd been at 54%, which would be over every requirement, they could stay at 54, but they can't go above 54 without a variance. Is that, do I correctly understand?
I want to be clear about this. The 54% arose from, let's say, 5 different structures on the property. Those 5 structures are in, but they couldn't then remove one of the structures and say, we were grandfathered with 54%. So it's only the structures, but you're correct in saying that if they had 54% and they only made improvements to those structures that didn't require more than 50% removal, they could keep those structures.
But the key is that he wants to go over what, on anybody's understanding, they've shown the city and even in the applicant's view, even though it isn't in the 2002 plat. So my understanding is that that's what why they need a variance, is because they're going over what has been either approved or, in the applicant's view, even shown previously. So that's why I understand that they're asking for a variance.
And that's why
on
they
the
need a
coverage.
variance, but the appeal,
Aren't we on
Can
the
they-
appeal?
can I
well,
just ask a
we're
review?
mixing them because it's
Can he withdraw his appeal if he wanted to and just focus on the variance?
He could. He could if he wants to, but he's entitled to a judgment on the appeal, and his position is that the city should not have considered the patio because the patio has been there, in their calculations, because the patio's been there for a lengthy period of time, correct?
Correct.
That's your case. Okay, so do we have any follow-up on that?
No.
All right, would this gentleman like to offer any testimony on the appeal?
Yeah, but I think the appeal
I
and the
need you
variance
at the
are,
microphone.
Yep. mhm.
I think the appeal and the variance
Okay,
are
so we'll just let you go ahead. So if you'll give us your name and address, please, I'll swear you in.
Russell Williams, 338 Hickman Street in Rehoboth Beach, Delaware.
Mr. Williams, do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, please proceed.
I am the across-the-street neighbor from Robert, and I have to say that as long as we have been, and my wife Carol Zinzer is here with me, as long as we've been coming to build and occupy our house across the street, that patio was existing. I think everybody agrees that patio's been there for a long time.
So how long has it been
We
since you've been?
started constructing in 2021, 2021.
221?
2021.
Okay,
So 3 years.
Yeah, 3
Okay.
years. The patio in question is hidden by a fence. We can't see it. There's a picket fence in front of it. It has no effect on our pleasure of view, if you will, and didn't even know that it was a problem until the appeal started. But what I would like to say in addition to that is I've talked to the neighbor immediately adjacent to Robert, and they have also indicated that they have no issue with the patio coming up to the property line in the 6 feet. Beyond that, the only thing I would like to say is I think that the city here bears some responsibility historically, because the house itself, when it was built, is in the 6 feet. Certainly, the building inspectors back then should have caught that. That's a long time ago. I mean, that house was built, 78 or so. So that house has been in that 6 feet for a long, long time. Somewhere the previous owner built the patio, that was also there. Various permits have been submitted. Never came up as an issue of being in the 6 feet, either the house or the patio. Since 2021, the house next to me was built, and certainly building inspectors went up and down the street and had ample opportunity over the years, at least since Robert has owned the house, to see visually that there might have been something wrong there. So it goes back to before he bought the house that there were some issues, and the house next door to him was built, nobody caught it. My house was built, nobody caught it. 2 doors up, a new house was built, nobody noticed it. So just want to say that we support Robert and in both the variance and the appeal.
Thank you, Mr. Williams. So wouldn't it be safe to characterize your testimony this way, that in terms of significant impact, you don't see any that's presented by the existence of this patio or the proposed plans to add additional lot coverage?
No, I don't see any significant impact.
Okay, so just for the board's, I'm sure the board recognizes that testimony is relevant to the granting or denying of the variance as opposed to the appeal. But thank you for your testimony. Is there anyone else who wishes to speak on the appeal? And Mr. Williams, if we get to the variance, your comments will be taken into consideration at that time.
All right, so do you want a motion?
We have to discuss it.
Oh, we want to discuss it?
Well, right, I mean, you could discuss it either pursuant to a motion, or you could discuss it and then make a motion and then deliberate on the motion. You have those.
Well, I'm happy to say that I don't feel that Corey made any kind of error in his deliberations in terms of the appeal. So that's my view, and
I agree.
The question wouldn't be, maybe Corey, I agree with you both that Corey did not make a mistake. But did the city make a mistake? Obviously, this home was built at some time, and that patio went in some time. Is it the city, at some time in 1993 or whatever, there was a building inspector who obviously didn't put it on the record. So I'm wondering if the city has any responsibility for not catching it over the last 30 or 40 or 50 years.
Right, well.
But it's not in the survey.
It's not in the
Yeah,
survey.
to me, the issue, and just in response to also Mr. Williams' comment, most of our houses are out of compliance with the current zoning.
right.
So that's
right.
not the issue. Nobody's saying that Ms. Kaplan's house has to be moved. The 2002 survey, as I read it, doesn't have the patio.
No.
So I'm not sure what it was that we'd be saying that the city should have done. That's why I raised the question about the tree issue in 21, but Corey said different department, not their job, and they wouldn't know that it hadn't, whether it was on a survey or whatever. So to me, on the simple question as to whether there's an appeal, I don't see a legal issue that we would be reviewing Corey's judgment on. So I think, Fred, it may make sense to try to dispose of that, just so it's clearer in the record
Right.
what we've done. So I don't know if there's been a motion
No,
yet.
we're waiting for discussion.
Yeah,
Can I add,
Yeah, if
ask
we've
one
all-
question related to
Yes.
that? Just real, the house, and there is a letter from the neighbors who own the house adjacent that I think Mr. Williams was referring to. If the city had some obligation, that house was built in 1998 or 1999. Should, when the building inspector walked that lot, should he have seen, hey, there's a patio right here?
Well, but that is not, in my view, and I don't think it's getting much traction with the board, relevant to the question of whether a possible mistake that was made years ago would have any bearing on whether you could add additional lot coverage in violation of the lot coverage restrictions.
I don't disagree with what you're saying there.
So I guess I'd like to make a motion that we deny the appeal
Second,
with respect to the judgment of the building inspector on this matter.
second.
All right.
I'm going to call a vote.
I'm going to call for a vote. Mark?
I agree with the proposal based on the fact that it doesn't fit the criteria for an appeal.
Okay.
I agree. I don't feel that we have to substitute any of our collective judgment for the building inspector. I think he read the code clearly and made a valid judgment.
Yeah, I don't think there's an appealable issue here.
I don't think there's an appealable issue either. So the motion passes.
Now, that's just simply on the appeal.
That's simply on the appeal, right. Now, we'll get onto the variance. Does anybody have any comments on the variance?
And the variance is on the quick check factors, right?
Yes.
Right,
Yes.
that's right.
And can we clarify, the variance is for, aren't there two issues? One is
grandfathering,
is basically grandfathering the patio, and two is 167 square foot above the lot coverage,
No,
the natural area percentage
New
limitation.
coverage. There's old coverage and new coverage.
well, it wouldn't be 167 over the old coverage because they already have 21, they have 21, because they have 2521 right now of natural area. So they have 21 square feet.
And so
Just in the, so if they were going to build a 21 square feet of something, they wouldn't have to.
So it'd be the 167 minus the 21, which is
146.
146.
Right.
I was never a math teacher, but I'm married to one.
Oh, good. Those math people are good people.
So Fred, I have grave concerns, frankly, about the patio being in the side yard setback. Forget lot coverage and everything else. But is that an issue that we deal with or not deal with? I mean, that we have no record that the patio was ever legally put in. It isn't in the building plans, it isn't in any additional permit that was gotten, it isn't in the original survey from Mr. Wingate. And typically, a surveyor would put a concrete patio in, and just like they put the shed in. They would typically put the structures like a concrete on and a deck, would be in the survey. So, so we have that situation. I have a concern about allowing things to be, it's only 6 feet. It's not much between your neighbors. And so is that something?
So the applicant's application includes that, it reads this way: in addition, the issue of the patio was never addressed at any request for permits we have made to the city since owning the house for over 20 years. Therefore, we're asking that the variance be issued as it is grandfathered, and removal would cause undue harm if, and costs if denied. So I think the applicant is asking for permission for a variance to keep the patio in its entirety and in its current location. And additionally, they're asking for a variance to permit additional lot coverage.
So if they took 6 feet, I mean, it looks like it, on this survey, like it's going right to the property line on the east side. I'm looking at the red survey.
No, it goes right up to the property line.
Right. And so if that 6 feet was removed, and I believe they have concrete saws, I've seen them being used before. And you had said earlier, if it was removed, it would impact the house, but that's not, side isn't up against the house, it's up against, I guess, a fence or something. So then, Edie, on your mathematical formulas,
Well, I don't know the actual dimension of it, so you take six times whatever the length of the current patio is, which I don't know.
I think it's 30
Size is
feet.
good, it's on there, but it's really small.
Okay, yeah, I used a mag,
Really small.
So,
The house is 5
I believe that's 24 feet,
yeah, it's 24
which would
feet of
equal
depth.
about 144 square feet.
So I think what we're in the process of doing is formulating a question we're going to put to the applicant,
yeah.
as opposed to deliberating on how the applicant should reconfigure their property at our request.
you've got 144 square feet plus the 21 that's already available, so you've got 165 square feet, and they're asking for 167 in walkways.
Right.
Right.
If that were the case.
If
but-
these are the exact, and I know.
Yes.
But
I
you're
kn-
talking about if you take off the side of the.
Yeah, I was following your thought,
Was
but
there a question that someone wishes to
I
ask
guess
the
my
applicant?
question to the applicant is, would you be willing to take off and have a 6-foot setback on the patio to ensure that setback?
Well, let me make sure I understood something you said correctly, because I sort of took offense to what you were alluding to. The survey done in 2002, clearly the surveyor didn't do a very good job, or are you alluding that I put the patio
I have
there?
no, I have no idea who
So
put the patio in.
the most convincing evidence we have is your testimony, and your testimony is that you didn't install
Correct.
the patio. And we need to ask if anyone is here who wishes to speak to this before we're going to deliberate on a motion or even make a motion. But I don't think there's anyone here who is desirous of addressing that issue. So the most competent evidence we have in the record is that you did not install the patio, and I think that's how we need to treat that going forward.
Right, because we don't have any documentation on anything, except that you said it was originally concrete and you enhanced it by making it block.
Well, right, I don't even think that pertains to what's going on. I think the question at hand, from what I understand, is am I willing to take a saw to cut the concrete 6 feet, 6 feet over? However, I don't think that's really the solution to the problem. I think once you open up, as they say, Pandora's box, the whole patio's gonna have to come up, because 6 feet over, and then there's, cracks, and the concrete itself is in poor condition. Well, then you gotta move it over and over and over, and all of a sudden, I now have a much larger area to have to work with than originally, and that's a financial cost. So there is harm to me, financially, if that were undertaken.
When you first found that there were some obstacles to your entire plan, what options did you come up with?
That I would go to the city and hope that there would be reasonable consideration and to grandfather the patio as is.
I see. But you know what, one thing here, and I'm going to reiterate, there's a reason for the size of natural area. I'm not meaning to preach, I hope I don't sound that way. The city regards the ground coverage as necessary to absorb surface water throughout the city. And it's always trying to make sure that as we get to these building permits and other things that are offered or requested, that each time that there is sufficient natural area so that citywide, which benefits all of us who live here, that there's not water pooling around.
Yeah.
So contributing to surface water, everything that's paved or covered over contributes, and you know that, you're a smart man. And the other thing is the city is trying to do is to protect overcrowding of land use. And your neighbors obviously, you have a great neighborhood and you're very happy there. But how would the neighbors feel, or what might be occurring if the property was purchased at some point by a number of people who had the largest group you could possibly put in there, and they were on the patio 24/7 talking and laughing, and the people might feel differently. So there's also a control of density, and the side yards and some of these other improvements, or these other setbacks help define good neighbors and separation and density. So those are issues that we have to continue to consider on the land that we're dealing with. I'm sorry, now you say what you want to say.
No, I hear you. Two things. One, on the natural coverage, whether the patio's there or not, I would say with the existing patio, I still complied to the natural coverage because I don't have those walkways which exceed. So
you have 21 square feet even.
Right, and I have I could build something for my dog, a little dog house.
Right.
But the 21, so that patio isn't affecting the water consumption, the water flow or everything, because the lot would comply with the patio. In terms of the what-ifs of parties and all that, I don't think that's the purpose of your board to anticipate that. The fences make good neighbors, and that's why I have a fence. I don't see any harm to anyone by that patio being there, other than no one has any record of how it got there. And I do think it's very easy to say cut it off, but given the condition of the patio itself, I'm going to say it's 50 years, almost 50 years old, or 46 years old. It's just going to, it crumbles, and that cut can create other cracks, and it's going to end up having to come completely out, which is going to add considerable to the scope of the original work.
What
Yes.
brought this all up, what brought the cutting of the patio all to fruition here is that you went to the city and asked to put the walkways in, correct?
Correct.
So you did the right thing, and I hate to penalize somebody for doing the right thing by making them cut half their patio off.
Well, I will just point out that there's a million grandfathered things in this town. And that's the way it is, until somebody comes and wants to change it. And then when you want to change something that's grandfathered, then you run into issues. And that happens all the time. But the idea is, over time, is that things that are grandfathered will come into compliance. And over time may take, 50 years, but eventually it will come into compliance. So anything, as Edie pointed out, anything that, every variance stays with the property. It doesn't stay with you. And so that's what we wrestle with, and that's what,
Okay, so we've been doing quite a bit of deliberating, I think, in anticipation of making a motion. I think we need just to confirm that there's no one else here who wishes to speak on this issue. Is that right? Because we're going to close the public hearing, I think, and then move into the motion stage.
No, go ahead.
Unless there are any additional questions for the applicant or for the city.
I guess the question is, if it's grandfathered and I did nothing, it could stay there for another 40 years. Are you going to order, if I don't get the variance, is there a order that I have to cut 6 feet of it off? I mean, how's that, what are we looking at?
That's a question for the city.
I can speak on that behalf. Just like when there was construction perhaps down the street, the city will not go in and start forcing you to tear out any structure. The only time that came in is when you applied for a building permit, and also which one that required a zoning review. So where the city wouldn't force you to tear this out, you would be kind of stuck where you are. And if any complaint were to come in due to the patio, we would have to take further action then. But where the patio is right now, you can't have any more lot coverage.
Right.
And so that would be if they would allow you to. I think the board has the ability to allow this to stay with the variance like that. But tearing the patio out would only be required when you want to change something.
But if I wanted to repair the patio, I could still do that.
You would have to come in for a permit for that. And at that point, I would have to reply with the same as I did here, that it was an unpermitted structure. So the city can't allow any action to be taken on that patio.
Okay.
Can I suggest we have two different motions? Because I think it's, in my view, there's two different analyses on the quick check factors.
Great.
So I would suggest we
close
have.
the public hearing is closed at this point. Okay, all right.
So I suggest that we consider the two variance requests separately, one with respect to the existing patio, and the second being the request for the walkways.
Exactly.
And if you want me to start, since I started talking.
Please.
I will move to grant the variance with respect to the existing patio. In my view, it meets the quick check factors, including the exceptional practical difficulty. I heard what Corey had to say. As Fred said earlier, there's only one set of evidence in the record that it existed when the Kaplans bought the house. We have the survey. This board has seen plenty of times when the surveys are wrong, and have to take Mr. Kaplan's sworn testimony that it has existed since he bought the house. And I agree with Mark that I don't think we should be penalizing people. And I understand, Jan, your question as to whether it's a penalty, but we want people to come and ask for permits. And so the fact that it is not on the 2002 survey is irregular and very unfortunate, but I will take Mr. Kaplan's sworn testimony that he bought it that way. In my view, I would grant the variance for the continuation of the patio as it exists today.
But let me ask you something.
Yes.
Why would you make this? So the other variance is for the sidewalks?
Yes,
Is that-
Yeah.
because that's additional
The
coverage.
two excuse me, the two variances,
They go together.
No, well.
but look what they
he's-
say.
He's asking to legalize what he has, and the applicant, of course, is not an attorney, but that's the way I read it, that they're asking to legalize what they have, and they're asking also for permission to add additional lot coverage, and
But the variances requested here are 270-26 side yards and 270-82 enforcement of chapter. That doesn't match, I don't hear it unless I'm misunderstanding. It isn't matching what Bill's saying.
What I'm saying, and Ms. Kaplan's not a lawyer, is that I'm viewing the way that the case has evolved in front of us is that there are two separate and separable requests. I could foresee us denying additional coverage for the walkways, but permitting the continued patio. And so in order to do that, because frankly, that's where I am, I would like to separate it with, and if we need formal consent from Mr. Kaplan, I'm sure we can ask him that,
no, you don't.
to say that.
You need a second, is what
Yeah,
you'll need.
Seconded.
that there's a variance with respect to all applicable chapters to permit the continuation, to treat the patio as now legally non-conforming.
I have two questions
Yes.
related to that. One is, see this little piece right here? Was that, I don't know what you call it without.
We closed talking.
No, I can't ask the building inspector?
Well,
Something, a question. Well, it doesn't look like it belonged there originally, like it was added.
I asked him about that, and he did say that it would, I asked Mr. Kaplan, he said it was a sort of something they just stuck in. I thought it was a handicap ramp myself.
No.
No,
this-
you were
this-
talking about the other side
that's-
of it.
That's dirt.
Was it-
Where the rocks are?
Yeah, that was never concrete. It was plant,
Okay,
there's
so that
been
can be
planting.
removed. That could be removed.
Well, yeah, that's probably in the overall count of the patio, so it's probably a little smaller, but that is a planting area.
But there's flagstone there, or this is where I'm talking about, this little dirt, this little jut out from the patio.
No, that's always been, that's part of that's on
Okay.
top of the
All right,
concrete.
that's what I was trying
Yeah,
to
that's
find
on
out.
top of the concrete.
Okay, that's all I wanted to find out.
Okay. It's,
All right, so does your motion essentially say that as long as he doesn't do anything to this, in other words, if he wants to do anything else, improve it, whatever, then he's going to have to get a building permit, and it's going to have to come into compliance?
Well, that's what, if that's what the city's rule is, and I think that's what the testimony was, then that's the case, but the motion doesn't have to speak to that.
No, but I understood that Corey's answer was because the city doesn't have a record that this has been approved, the existing patio. I thought our variance is effectively saying it is deemed to be legally non-conforming and that it could be repaired the same way anything else can be repaired that has been approved either because it was in compliance or because you got a variance. So my intention, for the record, is that that it's deemed to be in compliance, legally non-conforming. They can fix it if they need a permit to fix it, that the record would show that it is now part of the city records because this board has granted a variance.
So what if they want to replace it?
I don't know if I'd have to ask Corey, if something is legally non-conforming, with all the stuff that is legally non-conforming in this town, what happens when somebody wants to come in? As I understand it, if you don't change the footprint, you're permitted to do it, but I'll have to ask Corey that.
I think the motion
Alex.
is to legalize it.
Yes. that's
So if
effectively
it's
what I'm doing.
legal, then I believe it can be repaired. But it's being legalized as if it didn't exist and the applicant was asking for permission to install it, then your motion to legalize it, if approved, would grant the applicant the right to have a patio in that location.
Yeah, I'm saying that the patio is there. My view is we're granting a variance to say that it's legal to be there, and that we are doing on the assumption that it in fact was there when they bought it. And all rights and pertinences, as you and I learned in law school, would go with it, whatever that is.
So Bill, can you help me? You were splitting the two variances.
Yes.
But neither of the things that I heard you say match the variances that they're actually listed in what we're considering. So I want to know how we're covering what they actually requested and your split. As I understand it, you're saying you're splitting the patio as one variance and the walkways or the change in natural area as another.
Yes.
Is that correct?
Absolutely.
How does that match up with,
Well,
or do we worry?
Does it
I'm
have to
I'm a
match up?
matchy-matchy person trying to make everything work.
So
Maybe I'm wrong here.
Another way to potentially deal with this would be in the form of a modified approval, where the applicant, I'm just reading the tea leaves here, that the applicant has a harder time making the case for additional lot coverage than they do, based on your comments, in being permitted to maintain what they have. So if we could, you could also proceed with one motion for a modified approval, which would have the effect of denying the additional lot coverage, but legalizing the existing lot coverage. Does that satisfy your question?
I guess I truly need to understand what legalizing the existing lot coverage is.
It means that it would be as if it was permitted and allowed to be maintained there as legal non-conforming.
So if he wanted to put a deck, I'm sorry, if he wanted to put a deck over the top or do anything, does that all still make it legal non? I guess I'm really concerned about the legal non-conforming on a big slab of concrete with stone on top of it.
So we know.
That concerns me.
We know that in the setback area, if the applicant wished to add structure vertically, that would be aggravating an existing non-compliant feature and therefore would require an additional variance. It would not be permitted to make improvements vertically.
The applicant has made multiple comments about the poor quality of the concrete, that it's been there so long.
My comment is the poor quality of concrete, but it would support stone or something on top of it. I'm not digging up I have no intention of digging up the original concrete, if that's the question.
But if you're going to need to apply for a permit and put stone on it, it's the same issue.
Well, he's already put stone on it.
I don't
No,
think
he's talking about-
stone is not a structure. I know, well, I thought,
But it's takes away from the
But
natural area.
no, but it's already covered. The natural area is already covered. Guys, we have, I've counted 4,712,000 non-conforming structures in our city. That's hyperbole.
In actuality, you need to find a better life.
And so, and we deal with them all the time here without worrying about that if we grant it, that they could do something else. If they want to do something else, they have to come to the city. What I'm trying to do is be very simple here, which is that my belief is that the testimony says there's been a patio there for over 20 years. Mr. Kaplan would like to know that he can maintain that patio, and that's, from a non-legal standpoint, that's what I'm trying to do with the motion.
So
I think we're grandfathering what's there today. We're grandfathering what's there today. Stone, whatever it is, that's what's being grandfathered, not a deck above it or anything else.
Absolutely.
I don't think Jen, you really have to worry about it because they'd have to come back again if they were going to do any additional improvements.
I've been around a long time, and I worry about everything.
Well, that's a good thing, I guess.
So are we saying that if Mr. Kaplan decided to, just after he sat here and watched us all talk, if he says, I don't want to do any of this, and he walks out the door, which is okay, it's his right, and he decides he doesn't want to do his walkways, he goes home, end of story.
If the motion passes, then he is now,
But
he's compliant, if the motion passes.
But even if he doesn't, even if we don't pass the motion, if he doesn't have an issue that causes the city to get involved, right? 'Cause the reason the reason this all came up is because of the reason
I
this
think
all.
we're going to wind up the
The reason this all
testimony
came up
portion
was
of this.
because he wants to build walkways which impede on the natural area, and that found the patio.
All right.
So,
Can I ask you, a mathematician, something?
Yeah.
If this patio is grandfathered, not grandfathered, but determined to be legally non-conforming, but must remain as it is, does he have enough natural space to add his sidewalks?
No.
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 He only has 21 square feet.
I know, I know.
Right.
That's why Bill wants to divide it into
Exactly.
two.
Right.
We're gonna, that's part two.
He would without the patio, he has 402 square feet.
Yes, but with the patio, he
He has
cannot add,
21.
he cannot add what he wants in the walkways, and I purposely split it, because I think that, I'm with you on what your comments were earlier, Edie, is that we got a reason for the coverage, and I believe his testimony on the existing coverage, and I'm not prepared to add to the coverage. That's pure and simple is where I am, which is why I try to split it.
Well, would you take an amendment to your motion that the
Sure.
patio must remain as it is?
I guess I don't know what that means as a lawyer, let alone as a homeowner.
It's too subjective,
All
Jan.
right, okay, because I just have seen a lot of stuff over the years, so,
I think,
Why-
I think the city also said that the applicant is in some jeopardy, that there could be some sort of enforcement action in the event of some probably unlikely set of circumstances, but the applicant is in some jeopardy that he'll have some consequence, some kind of an enforcement action could be initiated against him, even though the city is saying they're not going to take that initiative of their own accord.
And I can tell you, as a former Realtor, when he goes to sell the house, he has a problem.
That's where,
Right.
so that's where
Very
I
good.
was.
Very,
Title
very good.
company's going to care about all
Very
this, so
good.
trust me.
That's where I was.
Right.
Yeah.
so do we have
Very
a
good
second
point.
for Bill's motion?
We do,
I
we got
seconded
a
it.
second there.
Okay, all right, I'll call for a vote.
I'm in favor of it.
So could we give our reasons? Because this is a variance, so we need to address the four criteria, primarily whether there's significant impact here and whether the applicant is facing exceptional practical difficulty.
I vote in favor of, because criteria one, the nature is not affected by the property, the character of the use is not changed in any, since it's existing anyhow. I don't think it would seriously affect the neighbors. We have a letter from the people next door, Thornburgs, and we have testimony from the neighbor across the street. No other letters nor testimony has been received speaking out against it. And lastly, I don't think it will have any negative effect on the neighborhood. So those are my reasons,
And we're just voting
just
on,
the grandfathering.
It's not a
On-
grandfathering.
what you're-
We're not grandfathering.
What you're voting on is the motion, and the motion was to legalize the existing nonconformity, which is represented by the area of the patio that exists in the setback.
I can't do that. I voted, I can't support the motion. I agree with Mark that the quick check factors, the first one, the zone is appropriate. The immediate vicinity is similar, but people are not as cognizant of the groundwater, and everything that's covered changes the way the groundwater moves. And one of our purposes is to make sure that this city keeps moving forward in a positive direction. And one of those is making sure that we're not creating situations where
So,
more
Ms.
groundwater.
Herron, the applicant is, this motion does not grant the applicant additional lot coverage.
Okay, right. It's just for the, it's to
Just for
grant,
the,
approving
it's
the
just for the
first lot
encroach,
coverage,
well, but he
yes.
could, the applicant could put the lot coverage anywhere they wanted. They have room to take that square footage that's in the setback and put it somewhere else,
It's not over the 2,500 square feet.
no.
even with it. So it's a question of whether you're going to allow the encroachment into the setback area. And if you want to pass,
I think I want to pass.
I support the motion. I believe it meets all four quick check factors. In particular, I think it would be extraordinary exceptional practical difficulty to ask the applicant to remove a patio that has been there by his testimony over 20 years. And as Mr. Townsend said, the approval does not lead to lot coverage more than what is permitted by existing city law.
Well, the vice chair, I had wanted to abstain. If we abstain, then we end up with 2.
I'm going to urge you to cast.
I know you are,
a
Fred.
vote, right. I mean, that's your
know,
that's your responsibility.
I know.
This is a limited motion. This is not
I
to
understand,
grant
I
additional lot
understand.
coverage. Right?
But I see things come back to haunt you all the time. All right, I'll support Bill's motion.
Okay, so would you like to cast, I mean, do you want to give some justification for your vote?
No, I don't.
Okay.
Frankly, because I have very mixed feelings about it.
And that's completely fair. That's a completely fair thing to say, that these are not always easy, and this is not an easy one for you. Ms. Herron, it's back to you.
I'm not, I can't support it.
She's all right, so we got her.
Okay, I thought she passed.
I did pass.
So you're voting,
abstain.
you're voting no on the motion,
That's correct.
right?
That's
And-
correct.
And, okay, so I don't think we probably need to hear a whole lot as to why. So you can, at this point,
So
declare
We
the,
declare we have a 3-1, and the motion has passed.
okay, so that leaves us with the additional variance requested for lot coverage, or from the strict enforcement of lot coverage to allow for these 2 walkways to be installed.
You want to go, Edie, or you want me to go?
I'll do.
All right.
I move that we deny the variance to allow any additional, to allow the lot coverage to fall before, the natural area to fall below 2,500. So in essence, to keep, I'm not saying this well. Maybe you can say it better. Let's see. I move that we deny the variance for additional lot coverage that impinges on the natural area zoning restrictions.
Okay, I'll second that. I don't believe that there's an exceptional practical difficulty. As the other members have said, the lot coverage regulations here are quite important to the city. I understand the benefit that Mr. Kaplan would see from additional walkways, but I don't see the exceptional practical difficulty. So I would support denying that requested variance.
I would agree with the motion based on the reasons that you just gave, Bill.
So you
And
want-
I would
you want-
also,
you
agree-
wanna
I haven't voted yet.
Right, so are we actually voting right now? So we.
I thought we were voting.
Okay, all right, that's fine.
You seconded
that
and
was a vote.
voted.
Okay,
I thought we were voting.
all right, that's fine.
Okay, and Mark voted, and Edie voted.
Well, I made the motion, so
Oh,
I
okay,
need to
so
vote.
I'm sorry.
I support the motion. I think that there are other options that the Kaplans can look at to deal with the lot area, and I hope that they're able to find an option that suits all of their needs, because I appreciate the fact that you came to us and your testimony and the time that you spent in preparing this information and letting us know about your situation. So thank you for your time.
And I also support the motion. The motion passes 4-0. 4-0.
All right, very
right.
good.
Okay, so I understand there's a variance to allow for the permit, I mean, the
The
patio.
patio, yes.
But there's no, to exceed the 2,500 square feet, that was denied.
That was denied,
Okay,
yes.
I understand. Thank you very much.
Thank you.
Thank you.
Thank you.
Just a- I was going to say, do we want to take a 5-minute break?
That's what I was going to
No,
ask. Yeah,
okay.
I'm fine, but.
Right.
I was a trial lawyer for a long
Oh,
time.
there you go. Experienced. All right, one down, one to go.
Okay. And we're back. I'm going to turn to the building inspector. Everybody ready?
So you could just say for the record that we have our full complement of members are here after the break.
Right. We're all back. The complement of members, it looks like the audience is back too. The building inspector is here. So Corey, if you want to give us your report on this property. Thank you.
Yes, good evening, or good afternoon once again. Hopefully not evening.
No.
This is the building inspector's report dated February 12th, 2024, for case number 1024-02, location 204 Philadelphia Street, Rehoboth Beach, Delaware 19971, tax map parcel number 334-14.17-362.00. The applicants are Steve and Shelley Mickelson at 3432 Arnold Road, Falls Church, Virginia 22042. The owners are the same. The subject, the applicant seeks the appeal of the decision of the building inspector for the following codes: 270-49.1, demolition and removal, 270-23, lot area per dwelling or dwelling unit, and 270-23.1, number of single-family detached dwellings limited. The applicant seeks request for variance from the immediately above-mentioned code sections as well. Nature of the request. The applicant is seeking, 1, an appeal of the decision of the building inspector for code section 270-49.1, demolition and removal, 270-23, lot area per dwelling or dwelling unit, and 270-23.1, number of single-family detached dwellings limited, and 2, a variance for relief from the immediately above-mentioned code sections. The purpose of the application is to permit the demolition of and reconstruction of one of 2 dwellings on the property. The property is located at 204 Philadelphia Street, Rehoboth Beach, Delaware 19971, and is situated in the R1 residential district. The property is a 50-foot by 100-foot lot with an existing primary dwelling and a registered legal non-conforming accessory dwelling. Application background information. According to Sussex County property records, the property was purchased by the applicants on March 19, 2012. The applicant seeks to appeal the decision of the building inspector to allow for the demolition of and reconstruction of one of 2 dwellings on the property, that being the primary dwelling. The applicant also seeks a variance for the same above-mentioned purposes if the appeal of the decision of the building inspector is denied. Appeal of the building inspector requested. The applicant is seeking an appeal of the building inspector to the following provisions: 270-49.1, demolition and removal. Any nonconforming structure or structure devoted to a nonconforming use shall be deemed abandoned if such structure is demolished or if more than 50% of such structure is removed. Such structure shall not be rebuilt, repaired, remodeled, or altered unless the entire structure is made to comply with this chapter. Code section 270-23, lot area per dwelling or dwelling unit. Under the district and use of R1, including accessory structures used as dwelling or dwelling units, minimum lot area per dwelling or dwelling unit in square feet is 5,000. And code section 270-23.1, number of single-family detached dwellings limited. Within all districts where permitted, no more than 1 single-family detached dwelling with its customary non-habitable accessory buildings may occupy or be constructed upon any lot. Per applicant's Exhibit G, correspondence titled 204 Philadelphia Review, dated January 12, 2024, the following rationale was given by the building inspector for the decision to deny the demolition and reconstruction of the primary dwelling. Start quote: although the parcel is recognized as legal nonconforming due to containing 2 detached dwellings with an area of 5,000 square feet, removing the primary dwelling with the anticipation of rebuilding a new primary dwelling would violate the above code sections. The demo application alone would be permitted, however, building and licensing would not be able to approve the construction of a new primary dwelling, even if the dwelling was shown to be zoning compliant with other sections of the code relating to lot coverage, building setbacks, building elevations, and floor area ratio, as the parcel would already contain 1 dwelling. Variance is requested. The applicant also seeks a variance for the same above-mentioned purposes if the appeal of the decision of the building inspector is denied. Conclusion, the demolition of the primary dwelling with the anticipation of constructing a new primary dwelling while maintaining a secondary dwelling would violate minimum lot area per dwelling and number of detached dwelling requirements during plan review for the new construction building permit application, thus was denied by the building inspector. End report.
Are there any questions for the building inspector?
I have one, just to be clear, the new construction that's proposed, have you seen those plans? And can you verify that they are the whole thing will be within the proper FAR as it's commented on in their application?
Yes, I have seen the plan set and the proposed site plan, and without conducting a full review, to my knowledge right now, it would be compliant with all other zoning sections.
Great. That was my only question.
Is the home currently, is the primary home currently compliant with zoning?
No.
It's a side yard.
There is one side yard encroachment.
How far?
3,
Okay,
I-
okay,
I believe, yeah, that would be on the survey.
okay.
338 or something like that.
yeah, 3.8.
Okay, Mr. Willard, are you representing the homeowners?
Him as counsel, and we have Mr. Burton as well.
Do you both want to come up? Is that what
okay?
your,
Yep,
whatever your preference is? You're the,
I think our game plan is, I'll say a few words, try to frame the issues. It sounds like, based on your quick questions, that this is what we call a hot court. You've looked at what's been submitted already. Mr. Burton submitted about a bunch of exhibits. You have all those, and they're part of the record. I made an attempt to try to frame the issue in my letter, if you've read that.
yeah, good.
So, and this is Mr. and Mrs. Mickelson, and they're adjacent homeowners here, or neighbors here that will speak, if necessary, in favor of the variance if we get there.
Should we
I don't
swear-
think we swear lawyers.
No,
do
we don't.
No, but why
No,
don't we
so we
swear?
need to swear.
Why don't you swear?
We need to swear Mr. Burton in.
Would Mr. Burton, name and address, please, for the record?
My name is Randy Burton. My address is 117 Front Street, Lewis, Delaware.
And do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
So we're proceeding on the appeal first, right? As best we can, we recognize that it can get clumsy at times, but we're going to do our best to focus on the appeal, and then the board will have the opportunity to move on that aspect of the application or choose to defer until after we turn back to you to ask for a presentation on the variance.
Very good. And I was in chambers when you gave your preliminary remarks about error, what the standard is, and not to give deference necessarily and be neutral. Having said that, Brandy has been involved with working with the city for close to a year on this project, reference the Mickelson's project. What is their project? They want to fix up their primary residence, which suffers from a lot of water damage and is encroached on one side, as you can say. And in so doing, he had to apply for demolition permit. And as that process ran its course, it was discovered that it was going to violate the 50% rule, regardless of what they did, because of the damage and a new roof. And so it was proposed to build a new primary residence. And so he submitted in anticipation of, I think, Mr. Shenek, is it? Or Corey? You've been calling him Corey, is it Shenek? Schenko, I'm sorry. Mr. Schenko's working with Mr. Burton. He submitted plans for the new building, which would, and I think for purposes of this appeal, consider those plans, as you asked the question, would be in compliance, complete code compliance, as far as setbacks, as far as FAR, it would be heights, it would be in compliant. And it would remove a primary residence that's non-conforming because of the setback and was built years ago. It'd be removing a building that's significantly been damaged by water damage and continues to do so by flooding. So why can't they do that? They can't do that, according to Mr. Schenko's analysis is because there would be two dwellings on the property. The other dwelling, the logic goes, is a garage apartment. And our argument is simply that the garage apartment is not a dwelling for purposes of your code. And the reason we're appealing this is a simple statutory interpretation dealing with, and I don't want to read my letter, but if you've read it, you've seen the arguments I make as to that, where it refers to the nonconforming statute itself. Such structure shall not be rebuilt, repaired, remodeled, or altered, and they refer to a structure. In addition, a garage apartment, it's easy to say that it's a non-conforming use, or maybe it's a primary residence because it has a bathroom and a kitchen and you can live there. But it's neither. You all passed a code provision designating these as existing uses. And I won't cite the code number. Some of you have been around and know they've changed over time. But you did that for a reason, as I can see. I mean, the statute speaks for itself. You recognized them. And you said, these garage apartments can exist, but we're going to put, we're going to set the clock right now to those that are existing now to tell us you want them to exist. And then you required all the homeowners to register them. And in this case, that property was registered as a cottage garage apartment, they call it. So those are basic arguments that it's not a primary dwelling, it's not a non-conforming use, it's something different. And it seems to me probably the intent, and some of you know better than I what the purpose of that was, it might because they serve a useful purpose for labor in town, and also because of the prevalence of them at the time. And I think, I believe, Ms. Kunissi, you mentioned that, well, non-conforming use is eventually, the idea is attrition maybe to get rid of them, correct? In this particular application, I don't believe, or I submit to you, it's not the purpose to get rid of their garage apartment, right? The purpose is, more importantly, to put a primary residence, it's actually a primary residence on the house that's in conformity. So it does what you suggest, bring a property into conformity. You're smiling at my logic, but I think
It's an interesting logic, since you asked my opinion.
yeah, I could read your face with that. But I think it makes perfect sense, and to the extent, and we can get to the variance, if the board has concern, and I was surprised in talking to Mr. Burns about that this hasn't come up necessarily before in the town because of the the number of cottages, garage apartments. But it apparently hasn't, and that's simply, this appeals decision is that if you're going to bring a primary residence into conformity with the code, and you can get a valid building permit, should that is otherwise non-conforming, should that make you tear down your cottage or make that cottage the primary residence? And that doesn't make sense, and based on how the statute is written and how garage apartments are set aside in your code, I don't think the statutory interpretation supports that either. We've suggested an out, to apply quick check on this because of the condition of the house, because they have to almost demolish it to make it habitable, reference, the 50% rule to fix it up. So in the second part of my letter, I've gone through all your elements of that, exceptional practical difficulty, spirit of the law, and I don't need to reiterate that now. If we get there, maybe we can talk more about it. There are witnesses here that want to talk about it doesn't adversely affect their properties. It's not a use variance because they're not changing the use of the property. It's residential, so it's a area variance. If you want to go there, that gives the city some cover in not creating some precedent that otherwise might concern them. I don't think it should. I think the statute's clear. I don't know how many cases you may have that somebody wants to bring their primary residence into conformity, and therefore they're going to lose their garage apartment, or garage apartment doesn't seem to make sense to me. So that's, I think, the legal issue that you're dealing with. That is, does it trigger demolishing the house? Does it trigger creating the garage apartment as the primary residence? And that's why the city's denied, or Mr. Burton and the homeowners pulled the brakes on this and said, well, we got to appeal. Because otherwise, you know, for us to fix up our house, we would just have the garage apartment. And they bought the house in 2012. They intend to retire here. They're in that mode. So that's where they are, and I'm sure Mr. Burton wants to add something to this, or if you have any questions for me, that's the appeal argument.
Do you wish to add anything to the appeal aspect of it?
Well, just to, Tim does such a great job that I probably should just keep my mouth shut, but, you know, most people in this room who know me know that I probably won't do that. I mean, you know, just again, to put a little bit of color to the history of this application, you know, Corey, as I've attested to in front of this group before, and I have a great working relationship, as I also have with Mr. Janis, and I have some history with 1959 section of the code, because I've been building in this town for 35 years. When this came up, I had a personal meeting with Greg Faris at the time and said, you know, I've got clients galore who are losing their minds about what does this mean is going to happen. And he said, what this means is going to happen, and it's written in his letter, it is going to bring all of these non-conforming structures into conformity, and that there will no longer be the possibility of adding a shower or a bathroom or a kitchen or a living room to any cottages that are not fully documented at that time. So when I made the application, I came in and I talked with Matt and Corey about that, because where it had begun was in the renovation of the house. When Steve and Shelley Mickelson came to me, they had already had some conversations over the last couple of years with the city about renovating the existing house. Renovating the existing house clearly, as Mr. Willard stated, would exceed, and there can be some arguments to the 50%, but let's just assume it exceeds 50%. And then the city's code says that you cannot rebuild that nonconformity. Their initial desire was to just renovate the house. And they weren't going to increase any of the setback issues. I had a couple of conversations with previous council of the town and some Mr. Willard and some others. And the second time that I met with the Mickelsons, I suggested, let's go and make everything on this property fully conforming, because the cottage is conforming. It is conforming based upon 1959 and the documents that were issued by the city. And I personally did 5 of those properties throughout town. I have my signature on them in files in the building official's office. Because it seemed to me that the best thing to do was to elevate the house. The new house would be elevated up out of the flooding condition that's been created, which will be a different argument if we end up having to go to the variance. But clearly, they've been negatively impacted by others being able to do what they wanted to do without proper permits, it would seem, because I'd be very surprised that the city would have given the permits to flood the Mickelson's existing home. I say that the basis of the appeal is matter of fact. 1959 supports the fact that that property was brought into full conformity when the documents were submitted to the city of Rehoboth, and that they are now looking to build a new primary dwelling, not a second dwelling. It's not in the strictest adherence to your own code. It's not a second dwelling. It's a structure. And that's where, but that's the language within the context that you read over and over. And I'm sure that each of you did your homework and read through everything that Mr. Willard submitted, and hopefully the copious pages that I did. And the reason that structure is italicized every time is because that's what we're dealing with, an additional structure on the property, not an additional dwelling. And to close, we need these kind of properties throughout all of coastal Sussex County. We need to have reasonable additional cottage spaces where the people that serve us all our meals and clean our rooms and work at our grocery stores and don't have the luxury that some of the rest of us have to be able to own properties can still afford to rent a place. And there's a movement afoot in the city of Lewis to actually change their code to allow these additional structures on properties where they make sense. The county has an allowance where if you have a single-family home and you need to, you have the proper square footage of your lot, you can build an additional dwelling unit on it for an in-law suite or for home health care or those type of things. I'm not saying that Corey is wrong. I'm saying that the city has historically looked at these incorrectly. And maybe the Board of Adjustments is reluctant to set a precedent because they worry about all the developers and builders and how they're going to try to exploit this section of the code. They can't. It can't be exploited. If you don't have exhibit, I can't remember all of my exhibits, but the exhibit B2, the letter, that's the letter, actually, I'm sorry, it's exhibit B. If you don't have one of these in a file with the city of Lewis or Rehoboth, you can't have that second unit on your property. So it's not opening a Pandora's box. It's allowing the Mickelsons to have a fully compliant home. And yes, when I designed, and we didn't go into a deep design, right? We gave minimal documentation to the city that they accepted, and we went back and forth on that, right? I mean, initially, I only wanted to give them a couple scraps of paper and not spend the Mickelsons' money before we had a decision. But it meets FAR, it meets lot coverage, it meets height, it meets every single zoning setback requirement that exists within the code today, including the 620 square feet of the structure that remains on the property be included in the FAR. Some could make an argument that you could get away with not counting that. I didn't try that. That would be a little too aggressive.
Are you ready for questions, Mr. Burton?
Yes, ma'am.
Okay. Does anybody have any?
Comment, maybe. I appreciate your discussing the workplace housing and all that, but how do we know that next week this isn't an Airbnb?
That's something that the code of the city of Rehoboth would need to
But
address
that's something that we have to think
otherwise.
about.
But that's not the issue here today, Mr. Saunders. I mean, the city is working on addressing those issues, but that can't be held against a client.
But you brought it up. You brought up that we need
Well,
more of
it's-
this workplace housing.
And I think
agree
that
with that, but I'm saying that we cannot, if we base a decision on that, then next week it turns out to be a weekly Airbnb, we have mud on our face.
Well, but the issue truly here isn't a matter of that being the question. The question is, does the city's code allow for both of these structures to exist on this property that it has been fully compliant for since 1991? And I submit the answer is yes.
You know, you mentioned a few minutes ago that you don't feel that you want to call a cottage apartment or garage apartment anything, a dwelling. I'd refer you to 270-4, which gives us the definitions of many terms used by the city. A dwelling, a building or structure which is wholly or partly used or intended to be used for living or sleeping by human occupants. So,
I'm sorry. No, I'll let you finish. I was going to ask Randy if I could address it. I interrupted you.
okay, thank you. And as you were speaking, Randy, you were talking about, and you used this phrase, you said, I can understand people want to build a second dwelling. Just 5 minutes ago, you said, when you were talking about garage apartments or cottages or whatever. I mean, you used that phrase. I mean, I know you were trying to use structure, because that's what you're trying to use as an imprint, not wrong or right, just true. I can tell that from what you sent us. But you too are using dwelling even for this kind of thing. So, and the city uses dwelling as a definition for as I just read. And the other thing I want to remind you is we don't do any precedents. We could decide something today and next month decide the exact opposite with a case that you might think was very similar. We deal with each case as it sits here, and you can see we spend the time doing it.
So that's true, particularly with respect to variances.
Right.
But we're on the appeal right now.
Appeal, excuse me.
Yeah.
Excuse me, that was my fault.
So if we come to this conclusion, and it's a conclusion that council doesn't like, then the city's going to have to abide by it until council addresses it through additional.
I don't have any further questions for the gentleman.
So you want to allow them
Mr.
to
Willard.
answer the questions?
Sure, I'll listen to anything.
Well, I think you're right in how you interpret the definition in 274. It's pretty broad, and all of us refer to, if you got a place where your head can hit the pillow
That's a
every
dwelling.
night and you can cook, it's a dwelling. But there's something called the primacy of being specific in statute codes, and what that dwelling definition does not include, it does not include garage apartments. And you might otherwise say, and you're smiling like the vice chair is, so you might. My point simply is, I think an accurate one is when you do define garage apartments, then you run the risk, if you don't want to, of not putting it in the definition of dwelling. You put it somewhere else, it's not included, okay? Because it's defined somewhere else. And if you're going to take a shot in a code, and I've done my share of legislative drafting, is you're either going to say it may include these things, not everything. You're going to need to update that dwelling definition to include garage apartments. Why? Because it's defined somewhere else. It's somewhere else in a code. It's a specific creature. And that's why I think, I get your point, but I think but for the fact that the code has defined that and created it as a separate creature, if you will, that argument's not persuasive. Although I understand it.
And we will want to hear from the city on this point.
Thank you. If I could just respond briefly to that. So keeping it simple here, I won't reread the definition of dwelling in 270-4, but the definition of garage apartment states in relevant part, facilities for human habitation. And so to me, it seems to read those two definitions in harmony, a dwelling is a broader definition, as Mr. Wheeler said, but then a garage apartment would be a type of dwelling. Other reading would necessarily divest meaning from the definition of dwelling, because not all places where people sleep are dwellings. That wouldn't be a reasonable interpretation to me. So basically, Corey saw two dwellings here and saw a code section that says, in 270-49.1, you can't have, did I get that right? Excuse me, sorry.
It's 270.
270-23. The lot area per dwelling. And so he essentially saw two dwellings, and it wasn't reasonable to determine that one of these is not a dwelling.
I have no questions. I happened to be here in 1991. I was a commissioner sitting up here. And I know why that was done. And it was done to prevent more, it's not really an issue, but I do know the whole story of that, okay? And that's not exactly how you're phrasing it, so. But I think we need to make a decision about the appeal first.
So the board, though, is restricted to the record that we're making today in making these determinations. So you've got the language in front of you, and you've heard some argument. I don't know if you need, if you have more specific questions that you want to put to the applicants, but I would just.
Public too, right?
Yeah, and we need to hear from the public. And
Could I just ask Corey one question? My understanding, based on a previous Board of Adjustment, was the entire back cottage was renovated, or actually was torn down and rebuilt. Is that correct?
Yes, that's correct.
All right, and is it still a garage?
No, I believe the Steve Cordick, the previous building inspector, had originally done a violation as more than 51% of the garage apartment was being used for occupancy or habitation.
Okay, I just wanted to confirm that. Thank you. That was my question. Anybody else have questions, or any
I think
public
you've
wants
got-
to speak?
I just want to ask Mr. Mickelson if he wants to say a few words. And this is just on the appeal, so it might be somewhat confusing, but I think you should have the opportunity. Mr. Townsend will cut you off.
And we will give you the opportunity to speak when and if we get, no, sir, we will want to hear from you again if we get beyond the appeal and we get into the variance application. But you're being asked to offer testimony on the appeal. So, Mr. Mickelson, is that right? Could you give me your address, please?
Steve Mickelson and my wife, Shelley Mickelson, 204 Philadelphia Street here in Rehoboth.
Okay, now do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do. I would like to ask that you do approve my appeal. And I and my wife, we've been trying to improve this property since we've owned it in 2012. And the flooding issue that we have is mostly due to the Belmore Hotel across the street and the lack of any storm sewers in our neighborhood. And because of that flooding issue, we've had water up to a couple feet deep on our lot. And I don't think any of you want to live under those conditions where you have water in the basement, you're sump pumping stuff, you have a thunderstorm come in and whoop, you got to get up, take care of business. And it has led to mold throughout the house, and no one should have to live in those conditions. And so we've been trying to work with the city for years to get this problem addressed, and we've never been able to find a solution that works. And so we enrolled Mr. Burton here to take care of our issues and hopefully correct the structure so we can have something livable and hopefully retire in someday. Thank you.
Any questions for Mr. Mickelson?
Nothing from Ms. Nicholas, but this is deja vu all over again of the last we had, where we really need to get rid of or discuss, and maybe divide it into two, the variance and the appeal, and,
Well, that was the same but different.
right?
But
We
we clearly
divided
are
the
not-
variance.
Right. In other words,
Does anybody have any questions
Yeah, I'm
about
trying
the
to,
appeal?
on the appeal, it's directed really to Alex. I want to understand, because it's a legal interpretation. You're saying that the fact that there's already a legally non-conforming structure on the property means that they cannot get a permit, excuse me, for a second structure, simply as a matter of law. The way that, and it, I assume would it matter if the second structure were conformed with current zoning rules? I'm trying to understand what there are plenty of properties with more than one structure on them in town, so I'm trying to understand exactly what the legal
Right.
issue is here.
And so I think, to answer your question, no, it wouldn't matter if it wasn't it was conforming because there'd be two dwellings there. Because going back to Exhibit B from the applicant's submission, the form for registration of garage apartments or accessory buildings, in that first paragraph at the top, it states in relevant part, I hereby register my garage apartment or accessory building which is being used for dwelling purposes. So to me, that is a dwelling. And I would have a difficulty interpreting that as not being a dwelling, and therefore there'd be two dwellings on the property, which would, as I mentioned earlier, and mentioned in Corey's report, would violate the number of dwellings allowed on the property.
So, I'm sorry, I don't want
No, no, and I gather that the applicant's legal argument is that the garage is not a dwelling in terms of 270-23.
Correct.
It's a structure, but it's not a dwelling.
Could you pull that microphone?
That is correct, Mr. Perelson.
Mr. Burton characterized it a little bit differently. He said that it was legally conforming as a result of the passage of what was 1959, but
1991.
well, the old the
1991.
old ordinance was 1950.
Right, but the ordinance number is 19-59.
He's talking about the ordinance number, but.
That's what I was talking
Yeah.
about,
Oh,
too.
I'm sorry, Fred.
That's fine. So, Mr. Burns, you don't share that view. The city doesn't share the view that structure is a legal non-conforming structure, or that your position is it's a legal non-conforming structure, and therefore it gets mixed in with all other legal non-conforming structures that need to be brought into compliance when a demolition like this is applied for. The applicant is saying that this particular class of structures is separately recognized in the code as something other than just generally legally non-conforming, and you don't accept that argument.
That's correct. I would say it's legally non-conforming, but it's still a dwelling, in short.
Did you have something to say, Mr. Burton?
Well, only in as much as, I mean, I understand that we may not prevail in the appeal process, or maybe we will. However, these are going to continue to come before you for years to come. So perhaps City Council, if we are not successful in the appeal, will look to correct this within the zoning code, because we all know how many of these there are throughout the city, and you can't take somebody's property away from them. I mean, you just, you know, if somebody comes and buys a property in downtown Rehoboth on, Rodney Street, and they pay $3 million for it and it has two dwellings, and then even to the point in the code now, if it just sat and deteriorated, which there still are a couple properties in Rehoboth that people don't take care of, believe it or not. I'm not sure how their family affords that, but, this is going to be an ongoing concern, and that's all.
Do we want to take a vote on the
You
appeal?
have to have the public speak.
Oh, I'm sorry.
The
I'm
public
sorry.
needs to
We
have
did-
the opportunity to speak on
wait.
the appeal.
On the appeal.
On the appeal.
But we did, he came up and spoke. We
Well,
asked for that,
we
right? Does
haven't-
anybody else want to
No,
speak?
he was introduced, and he's the applicant.
He's
And
the
the question is,
okay.
does anyone here
Want to speak on the appeal?
wish to speak on the appeal, which will not foreclose your opportunity to speak on the variance if we get to that point? And ma'am, you may come forward.
My name is Mary Ann Fry, and I own the property behind the Mickelsons.
And Ms. Fry, I'm
205.
sorry, I jumped the gun. You were giving me the address.
205 Munson Street.
And do you solemnly swear or affirm that the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
And I'd like to speak to the fact that to the fact they were turned down to tear it down. And I'd like to speak to the water problem. And I think I have a unique opportunity to speak on that because our address on Munson Street was called out in a Cape Gazette article, and I think the year was 2015, in talking about the water problem in Rehoboth. And the Mickelsons, as adjoining our property, and we both are victims of the onslaught of water from the Belmore Hotel, which was paved over. And we bought the property in 2001, and we had a little cottage. And we built a new home in 2008. We knew we could not have a basement in any way, shape, or form. In our house, we had to make sure it was at least 2 feet above the property because we had experienced 2 feet of water on our lot. And our little shed in the back, to this day, the water still comes, and we have water marks around the back, around the lot, around the little shed. 2 lawnmowers gone, and nothing can stay on the floor of the shed. And in the Mickelson's house, the one they did in the back, their garage apartment, we spoke at that time because we understood why that garage had deteriorated so much. It was because 2 feet of water sitting, on a wood structure, it's all bad. Their house also experiences this water. And, yeah, I wouldn't want to live with, all the damage of the water that I've seen over the last 22 years. So, that's just to say, I understand why they want to take that house down, and if they want to fix the variances, whatever, I think that's great for the city. But I also understand why they want to take it down. The damage is just, water damage is unbelievable. So, yeah, and, yeah, the mold, well, that goes without saying, yeah. So, yeah, I'd just like to say that our sympathies are with them. We had to, watch all these things when we built our house because we knew, and we've worked with the engineer they hired to take a look, and we've given them pictures of, we even get 2 feet in the front, comes up to our doorstep, because we get it running down Munson Street, running down Philadelphia, coming across from the Belmore. It's, it's really, and, Charlie Burton next door to us has some pumps in his basement. Mary Taylor, if anybody remembers that name, her little cottage also would fill up the basement with water. Water is a big issue in that whole area between Philadelphia and Munson. And I think, I understand, that's why people, apply for these, variances such as they are. It's because the property's been damaged severely by the water. So, thank you.
Thank you.
Thank you. I remember you from,
Yeah, from speaking for the little garage.
for the Belmore, when they wanted to put cement around
yeah,
their pool.
right,
I remember you, and I use your story a lot as examples on stormwater and the issues that we have.
I'll speak very quickly. I'm her other half, not the better half, just the other half.
And just,
Howard Fry, and I'm at the same residence, 205.
and do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
And I will say that, I think everyone here recognizes that there is a water issue. The water issue is probably not terribly relevant to the question of whether these garage apartments constitute dwellings and therefore offend the 2 dwellings on 1 lot issue. That's what we're trying to wrestle with right this minute. And if we are unable to find in favor of the applicant on the appeal, then we're going to take additional testimony on the issue of the exceptional practical difficulty the applicant is asserting in terms of their efforts to make normal improvements to their property.
Okay, well, specify exactly what you mean by the appeal.
The appellant is saying, the applicant is saying that the garage apartment does not constitute a dwelling, that it is a separate creature, separate animal defined in the code, separate from a dwelling, and therefore by demolishing the existing dwelling, they are not potentially running afoul of having two dwellings on one lot once they're issued a building permit or denied the issuance of a building permit to construct a substitute home for the one they're demolishing.
I guess basically what I want to say is I don't understand why they have to live in a house that floods when the issue can be addressed. It's quite simple to me. This is the third time I've addressed this issue about water, but since you don't want to hear it,
Oh, no, 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 we're specifically inviting you to give us testimony on the variance aspect of this if we get there. But the question is not whether they should have to live with water damage. The question is whether they can have two structures on one lot, or whether a garage apartment and a new home don't constitute two dwellings under the law. So it's a legal question right now.
well, since I'm not a lawyer, I can't handle it. I think it's foolish.
But you're on record as supporting the appeal.
Oh, absolutely.
All right.
And Mrs. Fry doesn't have to come back and give it all again, right?
She doesn't, no. We may
So we
hear
get
from
point
him.
for a motion and discussion?
Does anybody else have anything that they would like to address the board with?
This
This
gentleman?
is related to the appeal, but thank you. Yeah, come on up. Sound like the Price is Right.
Yes, my name is Wayne Steele. I own and reside at 206 Philadelphia Street, adjacent to the Mickelson's property.
Mr. Steele, do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes, sir, I do. I'm not sure what to say about interpretations. I just go with common sense usually, and there are two structures. You can call them structures or dwellings, but they're on that lot right now. They've been on that lot for years and years. My family has owned 206 Philadelphia Street since, I believe, 1952. So I won't get into interpretations. I'll just say that I support what the Mickelsons are attempting to do at 204 Philadelphia Street.
Thank you.
I have no objections. I don't know if I can stay and say this again if you indeed go to the variance. So if this serves as my testimony for that as well, thank you.
Thank you,
Thank
Mr.
you.
Steele.
Jan, we have a letter, I believe, from Mr. Steele on record anyhow.
Yeah, we do.
Right.
We have all the, yes,
If you have to leave, you're covered.
yes.
So I'm Jared Bowers. I live on the other side of the Mickelsons as well, and I just wanted to say I fully
Mr.
support.
Bowers, the address, please.
It's 208 Philadelphia Street.
Do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes, sir. Yes, sir. Just wanted to say I fully support what they're trying to do as well. I think it'll definitely improve the block, and I run by every morning and see how bad that water is after a storm, so they need to do something there.
Thank you.
Thank you. So,
You ready
the
for
hearing
a?
is- the hearing on the appeal is closed. Do you do it that way? How does one do it when you have two?
No, you can just agree not to take any more testimony or argument at this point on the appeal.
Nobody else has anything on the appeal, correct? Okay. Then we'll not take any more testimony or argument on the appeal, and we'll discuss it among ourselves.
Or you could just call for a vote.
We have
Well,
to
I
have
have
a
to have a
motion.
motion, Mark.
No, I mean, we could call for a motion on the vote. I don't think there's very much to discuss.
Well, I didn't know. I'm like,
I move that we deny the appeal because I don't feel that Corey has made an error in interpreting the code the way it's written. I think, I feel for these folks, and I'm really interested to hear about when we look at the variance, but I don't think that anybody can think that the house doesn't need to be resolved in some way, but that's the question that we will deal with at the variance if we move to that point. But so my motion is to deny the appeal because I don't think our concerted judgment should take the place of what Corey.
Well, it does, your judgment does take the place of the building official unless you uphold the building official's decision.
Oh, I am.
And if you're upholding the building official's decision, then tell us why, in your estimation, the building official really doesn't matter if it's Corey's decision or.
Okay,
but
I believe
why,
that.
Why is it correct?
Okay, I believe the building official made the correct read. My read of dwelling is similar to many other people who've said it today, not with everyone who's talked about dwelling today. I believe there are 2 dwellings on one lot, and according to city code, and that Corey, the building inspector, made the correct judgment about that, and these other issues followed that, that the appeal is based on, that you can only have one dwelling, and so that you can't do a demolition and rebuild if you have more than one dwelling. So I'm not sure I said that clearly, but.
Is that all a motion?
No, that was my, he said Fred said I had to give reasoning when I read the motion, when I created the motion. So excuse me.
So as we recall, 2 dwellings are legal as they exist right now.
Yes.
Right. But the act of demolishing one of the dwellings.
Or changing 50% or more
Or
of one,
changing
which is.
50% then eliminates the argument that these are.
That they can have 2.
That it's legally non-conforming.
Correct.
And they must bring it into conformance.
Right, and my motion says that the building inspector was correct in interpreting the code in that fashion.
I second that.
Any discussion? Okay, I'll call for a vote. Bill?
It's a close question, but I don't think that the code is particularly clear, but I'm prepared to go along with the building inspector's interpretation on it. I think it's a fair interpretation. I've really spent quite a bit of time trying to work my way through it, and I think it's frankly ambiguous, but I'm not prepared to. So I don't think that the building inspector's judgment on this was incorrect.
Mark?
I'm open-minded on a variance, but I do think that I agree with the motion that there's no need for an appeal to the building inspector's determination.
Edie?
And I vote yes.
And the chair votes yes. So the appeal is not.
Denied.
The appeal is
Yeah,
denied. I was going to say it's not upheld.
So then now we proceed to the variance.
That's
Right,
right. So we can turn, I don't think we need to go back to the city on the variance. We can turn back to our applicants. We'll hear more from the applicants on the issue of their perceived exceptional practical difficulty.
Yeah, I think, speaking of practical difficulty, so it's like, now what? They need permission, they're asking permission to build this new home that's compliant. So the variance would be from section 23, I guess, that there's another dwelling unit on there. I mean, that's a simple way to look at it, because it's compliant. So I think, and this may be a question for your solicitor, but is what's previously been said as part of the record for this application as well, the variance?
I think so, yes.
Yeah, I
The
just wanna make that
testimony
clear, 'cause
that
I
we
don't-
heard and.
We go around in circles, and you guys have heard enough, probably. And you know the conditions, expect exceptional practical difficulty. They've owned the house since 2012. Mr. Mickelson's testimony is more important than mine. You have about 8 pictures dealing with the flooding situation. I think the testimony will be, or was, that as they approached the town to try to repair this, that very quickly they were above the 50% threshold. So it is kind of exceptional, right? So if you want to say, well, why don't you just fix it up and you can leave it in the non-conforming? It seems to me the testimony and what's been submitted thus far is you bump up past that 50% right away. So therefore, their difficulty is they can't fix up their house unless they build a new one, and they're offering to build it totally in compliance. So the only problem is the apartment in the back. It's not against any public interest, I believe. This is, as you said, there's no precedent. This is specific to this property, and they have a unique property, maybe not totally unique with that area that's experiencing this water damage, which really is the backbone of the reason why this is unique. It's the property's in distress. There's also, and Mr. Burton's has set forth the reasons as well in his submissions, and I parroted some of it. Without granting the variance relief, the Mickelsons could not improve their primary residence to a safe condition. The spirit of the rule, we may differ somewhat with it. Some of you've lived through the reason they had the old rule. You denied the appeal, but the spirit of the rule, of your law and your zoning law would not be, I think, affronted by letting them approve their primary residence in compliance with your code and in compliance, especially with the FAR. So I don't think it flies in the face of that. And I don't think it would impair, as your last element, to substantially impair the intent or purpose of your zoning ordinance. You're going to have to have the same house or a compliant house, if you will, moved into the center and compliant with your setbacks and everything else. So quite frankly, to be an improvement, and it's a residential area, but for the hotel and other things around there. So with those 5 elements, I think this should meet your variance requirement. You may hear more from the applicant or Mr. Burton.
So I think, I don't think there's any question about there being a legitimate need for the property either to be repaired or demolished and relocated. The rub here, though, is with regard to the cottage. So I think the board is going to want to hear why the cottage should stay, maybe some history on the cottage, maybe some testimony as to the investment in the cottage, the fairly recent variances that may have been considered in the past.
I understand, and I think the applicant should talk about how it's used, and Mr. Burton has more history about the cottage itself.
Very good.
You have in the record that it was approved as a registered apartment back in the day, so.
And also we have in the record from Mr. Shimko that it was demolished and renovated or rebuilt in 2015 or 16.
16, 17 is what the text says here.
So that you did get a variance to do that. And according to Mr. Kordick, it is used as a dwelling.
Yeah, I don't think that anybody here is arguing. We were dealing with semantics of legal language in the appeal, but I don't think that anybody is sitting here trying to pull the wool over anybody's eyes and say, this isn't a second, use on the property. That's a given, and we have tons of them throughout the city.
Could I just ask? Can I ask council something for a minute?
All right, please proceed.
Sorry.
So, I think that based upon 1959 and the documentation that was submitted in 1991 to support the permanent non-conforming use of a second dwelling on this property allows the client, and this is one of the things that I was alluding to earlier. I had clients back then, Mrs. Kunisey, who were up in arms about what does this mean is going to happen if I want to renovate my existing house. And I had personal meetings with Greg Faris at the time, and it was, there's not going to be any taking away of the use of the rest of the property. This is to stop the proliferation as you well know, of non-conforming, because people were going out and taking their garages, and, they bought a house in 1987, and they were new to town, and they said, well, Fred and Wilma down the road, they got a real nice guest cottage over there. I'm going to make one in my garage that's out there. And the city said, we got to stop this, or they're going to be everywhere in the city. And they put an ordinance together, and it's 1959. And it allows the declaration of all of those properties to be perpetually used as an additional dwelling.
As long as they're not changed.
As long as they're not changed, Mr. Burton.
As long as they're not expanded. As long as they're not expanded. And we're not expanding the use of that cottage. We're not doing anything with the cottage. We are asking to be able to put a proper habitable main structure in the front of the property, where the existing house that is there is in such bad shape that we would exceed 50% renovation, and it becomes then non-conforming. But does it become non-conforming? I guess that was asked and answered. The appeal was denied. So now the question is the city going to be in the business of taking away the full usefulness of people's existing properties? I don't think that's what the intent of 1959 ever was. I don't think that the intent of registering these properties that existed were so that in 2023, if a person came along and rightfully wanted to improve their existing home to be fully zoning compliant. We're not asking to work on this building that has all kinds of other nonconformities, right? I mean, the top of the foundation wall is low, the building encroaches into the setbacks. I mean, we could go on and on about what it is. That's not what we proposed. We came back with a proposal to razz that house and build back a new structure that will meet all of the existing zoning requirements, setback, height, floor area ratio, including the 600, and there's question, we ended up, the Mickelsons and I just acquiesced to the 620 square feet. There's, the application has a different number than 620 square feet, but we're just calling it 620 square feet, which means that we can build an 1,880 square foot house on that property.
Randy, can you describe briefly what the variances that went on 5-6 years ago, what those issues were and what was done?
I think that Mr. Mickelson can speak to them better, but I can give you my perspective. I mean, I think that, and I think this has changed in the new building officials that we have, but their codes are gray enough as they are, Mr. Pearlstein, and in the era when those applications were being made, there was a lot of transition in the building code office. There was a lot of interpretation of what was allowed and what was not allowed. The primary reason they needed a variance is because they needed to elevate that building to get it up out of the floodplain. But it was non-conforming in the setbacks, right? And it's clear that you can't aggravate an existing non-conformity in a setback without seeking a variance to get it. So that was the beginning of it. There was some other gray areas that came about as far as in 1991, what were the uses of the space inside of there, but the Mickelsons didn't expand the use of the property any in their final applications. But they had to come back for a second variance because there was a misinterpretation at that point.
And Could I just add, I can't tell from the survey, but is it now located 4 feet from the property lines on the side and the back? Okay, I can see Mr. Mickelson shaking his head, thank you.
Yeah,
Because
and
the
again,
number isn't written on here.
well, and again, they improved,
I
right?
understand it.
Before, it had
No, I
greater
understand it.
encroachments.
I understand, I understand.
Mr. Burton, may I ask
Okay.
you, with the new home, they'll still have a water problem, but it'll be raised up so their feet won't get wet. Is that basically true? I mean, you're not solving the flooding problem, you're just.
And we're gonna
pulling
run
house
all
out
the
of it.
water onto these nice 3 neighbors that are back here. What we're
That
gonna
is sort
do
of a
is they don't-
consideration.
They're unwitting victims of the future.
Well, what are you gonna do with that water?
Well, I mean, we haven't begun to address that complete. Number one, the top of the foundation wall of their new home is gonna be 33 inches above
Well, that
where
was
the
my
top of the
question. So their feet
foundation
won't be
wall
wet
of
at
their
any rate.
existing. And there's all kinds of great technology to waterproof from the inside. But there is a secondary question. I don't think it's for today. It'll be an issue that the Mickelsons and Corey and I deal with is how are we going to get some of this water back off of this lot when it shows up, right? There's not much we can do about it. We could ask the city to go back to the new current owners, since it's not a longtime native family of the Belmore, and ask them to tear the blacktop out that was put in that isn't a permitted use. It shouldn't have been done. I mean, Mrs. Herron, you talked about 50% coverage. That's 100% coverage of blacktop, impermeable. When it was stone, at least it had a chance for some of the water not to come into their house. You know,
It's an R1 block.
right? It's not a commercial.
Belmore.
Right. So I think that we will address some of those issues, but the greatest thing is we're going to elevate the house, and we're going to have that thing up out of the. We're taking it to the maximum height that's allowed to still be able to have a basement underneath of the house.
And we'll hear from Mr. Mickelson, but that's going to happen, right? I mean, you can't allow the dwelling has gone beyond its natural life. The primary dwelling needs to be demolished, correct?
Yes.
Yes.
I mean, the whole purpose here is, I mean, you can see by the history here, Mr. Townsend, that, I mean, my first meeting with them was June of last year, right? They had already been working on it. We had hoped that we could start a house that they might be able to occupy, fall of 2024. Now, what we're really hopeful for is that we can prevail here in a variance today, finish up our application with the building code department, and be able to demo before May the 15th, so that we don't lose another 4 months of construction time.
I have a couple, excuse me.
No, go ahead.
No, you.
Well, I mean, I think we want to hear from Mr. Mickelson at
We
some
do.
point.
I have some questions for him, but I had a couple for
Okay,
Randy first, if I might.
go right ahead.
Okay, now, Randy, a few minutes ago, you said, you were talking about a permanent, that they had been granted permanent status. I'm not sure that when I go back and look at 1991, and I don't see that they're granted permanent legal non-conforming status, like under all conditions, no matter what. I don't see that blanket approval for anything you ever want to do. I'm not saying there wasn't. So I'll stop with that.
Understood.
I don't think that we can use the word permanent.
Does that go to the question of the appeal or the question of
the variance?
Okay,
I think.
okay, I'm sorry.
Okay, and we all have agreed, I think, peripherally, that one of the things that people don't want is a lot of a proliferation of cottage, whatever we want to call them, cottage apartments, garage apartments. They're all dwellings at some level because of the definition. They're under that umbrella of some sort, or they're places where people sleep. And so the city has been trying to deal with population density since the early 90s, as you said very well, about, hey, we got to stop this and get a handle on it. But that doesn't mean it's in perpetuity, that something that's allowed once is allowed as it was forever and ever. And you've used the term main structure, main dwelling. Mr. Willard, you've used those terms as well. I know those don't have legal definitions at all, but when we look at code, we are seeing 2 dwellings on a lot, and that's what we're going to have to consider as a variance, dwellings, not a main dwelling and a not so main, or a primary or a not so primary. So I think we have to go back to the fact that we're looking at 2 structures, 2 dwellings, 2 whatever you want to call them, but the code says 1. And so then I have some questions for Mr. and Mrs. Mickelson whenever they are.
And I also do too.
But did you ask?
Oh, did I ask a
Was that a
question?
que- was
I'm
that a
sorry,
question?
that wasn't a question.
Do you
I
want-
was listening
do you-
for what the
do you wanna
question was.
respond?
I'm sorry.
Do either of you want to respond to that, or?
Do you think that there's a definition anywhere? Have you found one of main structure, main dwelling versus secondary? I mean, you use that term too. I have not seen those things other than in some of your presentations to us, but I'm talking about in code or anywhere else. I don't see main and secondary or primary and.
Right. I think you're right about that. You don't see it. And I would just make the same argument I made, which I lost, which is the fact that, yeah, so I don't want to waste your time.
Okay.
Garage apartments are defined and they're a special, I keep using the word creature, so that's what they are. And they're different from just a dwelling. They're special. But you didn't buy that necessarily. So I think the variance I mean, really, when you cut right to it, they have a decision to make. They're going to fix up their house that's falling apart or that's flooding, and they have to demolish it and live in the garage apartment, or get some kind of relief to be able to build a new house in compliance and keep the garage apartment. That's why we're here.
Yeah,
And I think that, go ahead.
There is actually a
Go ahead,
definition.
Bill. Yeah.
The definition of garage apartment in the definition section says that, lots of other words, in which garage is detached from any other building and is separated from the main dwelling on the lot by at least 6 feet. So the actual term main dwelling is
good.
used in the definition of garage apartment.
So
I paid for my law degree that way.
And I mean, just to piggyback on that, and, you know, within the BOA's authority is the authority to allow a change to a non-conforming structure. It's item D in your charge.
Right. I wonder if we could talk, if the Mickelsons, I have some questions for them that I think would be more appropriate addressed to Mr. or Mrs. Mickelson than to Mr. Burton.
I'm fine. No, I'm fine.
You're still under oath, and you can adjust that microphone if you think
Yeah,
your
I don't
voice
know
is
how
not
to do
being
it,
picked
but
up.
you could raise it up.
I got it, thank you.
Would you prefer to sit, sir? You're
No, I'm
welcome
fine.
to. Okay.
Do you want?
As I stated earlier, we've been trying to get out of this situation since we bought the home, 2012. So essentially, this has been a 12, 13-year process. And to tell you the truth, it's been really frustrating. Frankly, if I knew any of this existed, I had any experience with the city code, I wouldn't have bought the place. There's just no way. It shouldn't be this difficult to improve your property. You know, I mean, why is the city fighting us to spend money here, to live here, to retire here? It's beyond me. It's beyond me.
Well,
Go ahead.
Can we, but I want to give Mr. Mickelson a chance to tell us why this is a question, this is not a question on the main structure. This is, you're going to have a new home built on that house, correct?
That's our
tent if we get permission from the city to do so.
Okay, so how much do you want this garage? I think the board needs to know how much you want this
Well,
garage.
we went through this
Garage
entire
apartment.
process, starting in 2015, to go through a variance request and several appeals for the cottage house. That took almost 2 years to get the permitting process. Another year for construction. So we finally started construction 2016, carried into late 2017. Cost us $170,000. Why do I want to throw away $170,000 for what I understand, if I understand city code, a structure that's allowed, fully compliant according to 1959.
So can I add to that, Mr. Townsend? Because I know what you're trying to get at, and that is, you know, I understand the water problems, because I mean, Mrs. Fry shed tears the last time she testified. It was a big deal, and it made quite an impression on me.
We tried to work with the city
Well,
on getting storm sewers installed.
And
Our neighborhood went together, and we'd go over and talk to various city officials, one after the other, yada, 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 right? We finally got a study done. They came up with a number, what the city needed to have to complete and correct the problem. It died. Money's been allocated for all kinds of other things, but nothing for storm sewers.
Okay. All right, so we don't really know whether storm sewers or whatever remedies that we've talked about in the area would actually even work. I mean, we don't know, we're not hearing from the experts who could tell us what the fix is or how much it would cost. But what we are here.
We don't have one.
But we're here to hear from you to establish your, what you perceive to be an exceptional practical difficulty. And it's a desire to maintain the garage, which you spent $170,000 on, right? Now, the second, or the third, excuse me, criteria that this board applies is to what extent your desire to have these two, well, I'll say a dwelling and a garage apartment on one 5,000 square foot lot. How does that, in what way does that impact your neighbors, in your estimation? Because
Two structures?
yes, to have them. I mean, oh, excuse me. To what extent have you, having had those two structures for a number of years on that lot, impacted your neighbors? We've heard from some of your neighbors. In your estimation, what impact has that caused others?
Positive or negative?
Well, yes.
I think it's been positive for several reasons. It allows vacationers to come, get an affordable place instead of some place like the Belmore, which is 10 times more.
So
in money.
there's.
But it's there. Our whole street, Philadelphia, there are numerous garage apartments, cottages, whatever you want to call them, as part of the property. Some of them are quite large lots, and they're all going to be here. If they want to do anything to their properties, some of them have just changed hands. You know, when they think they have enough money, they're going to be here. And they're going to be arguing the same things that I'm arguing. You know, we've met every city code. You know, we've got the 4 parking spots. We have to keep the 4 parking spots. We're wanting to be totally code compliant. We would just like permission to fix our own home.
Have you considered keeping the garage apartment, which is really not a garage, and attaching the main house to it? So you have one large house. Your setbacks are 4 and 4 on the new
Yeah, which would be
build.
non-compliant. We'd
No,
have to go
only
to
the back
6.
would be non-compliant. The rest would be compliant.
We need to be 6 foot on one
I
side.
understand that. You understand what I'm saying, Mr. Burton?
And
I know it's done. It's
The whole cottage would be non-compliant.
Can't hear. Yeah. We need
You've got to
pick
come
you
up to the microphone. We understand that. What we're trying to do is,
But if you look at the survey, I mean, you'd be exasperating the problem because the back, yes, because the rear yard setback is 15 feet. This entire structure
I know
would
it's
be
4 feet.
sitting, and then he would not be able to make the connection to it because that building isn't greater than 15 feet deep. So then you would be granting a variance for them to build a building out front that is non-compliant by the attachment in any way to that building because that building sits beyond the setback line.
well, it's on the setback line for an accessory building, not for a main structure.
No, I'm talking about the front of that building and the back of his new house.
I'm
are
just
gonna be
telling you,
more
it's being done all
non-compliant.
over Rehoboth, and I know a lot of the houses that it's been done to. So it's in the same situation that you all are talking about, where there was a cottage and a house. House was torn down. The cottage then becomes the main house. So then the cottage gets extended within the setbacks. It's a solution. That's all I'm trying to say, is that there are lots.
But it's a solution that takes away the value
of a garage
of
apartment that's a rental unit. I get it, okay?
No. Overall, it's a taking of their property value by the city not
I'm not here
allowing.
to argue. I was trying to find a solution
Well-
that other people have used, that's all.
But the argument becomes, I mean, when all of these things keep coming up is, anybody that buys these properties in any place, it's based upon an appraised value.
I don't really need a lesson in real estate, Mr. Burton. Let's we're trying to find a way to solve the problem, okay? And the code is very clear. And it's been upheld in the Supreme Court just recently about 5,000 square feet per dwelling unit. So it's not some archaic thing. I mean, it's gone through.
So you're telling me then, can I ask a question about that statement that was just made?
Well, because right now, we're on the variance. And the variance is the opportunity for the applicant to tell us why he should be given some relief from the strict enforcement of the code. Since we've gotten past the appeal, we're not arguing about whether there are two units on one building lot. So,
We accept that there are 2 dwelling units on here.
Okay.
And the client's desire is to keep them. But are you saying that there's case law in the state of Delaware that does not support this application in the city of Rehoboth?
I'm not saying that.
yeah, so
I'm not
what
saying
was being referred to was something that might have had some kind of a bearing on the issue of the legal interpretation on the appeal. But we're now beyond that, and we don't want to go backwards. And I don't want Mr. Mickelson to feel like he's been given short shrift. I mean, because he's been asked quite a few questions that were lengthy that weren't easily answered. And I want to make sure he's had an opportunity to tell us what his difficulty is, to what extent this affects him to lose the garage that he invested in 2017. Now, maybe $170,000 is not much to you. I don't know, but maybe this is your opportunity to tell us what it means.
If I knew this was all going to happen, I wouldn't have bought the place. $170,000 means a lot to me. I've been trying to make my property livable and code compliant. And I get shot down every time I turn. Whether it's with the cottage house, whether it's the main house, it's been really difficult. Really difficult. And I'm not the only one that's going to be here. We have a lot of extra properties on Philadelphia Street with more than one livable unit. So I don't understand, why it has to be made so difficult. why can't I improve my own property? As long as I'm meeting the code, that's all I'm asking.
May I ask you a question or two, sir? Thank you for your time. You had said that it allows tourists to come. Was that because you were able to rent the front house and you and your wife could come and enjoy the cottage house? Or did you do the
That was-
reverse, or what you were?
And both properties have always had a rental license,
Oh, I see. Mhm.
way back from whenever I know. And so, depending on guests, opportunities to rent, we have taken in some income. I've paid my taxes here too,
Sure.
for rental income. We might be staying in the back house, we might be staying in the front house. You know, it's worked out nicely to have
The option.
two. Yeah. And it was one of the things that was attractive about the property, that there were two. And they were legal to, according to 1959. What I'm hearing now is 1959 really doesn't mean much. So this is news to me.
So you have 2 certificates of occupancy
Yes.
and 2
Two rental licenses.
2 rental licenses. And I'm wondering, in all of your deliberations over time, and did you ever consider, as I think Jan was just kind of alluding to do, couching this as an addition to the existing dwelling, which is the cottage apartment or whatever we're calling it?
That just opens up another can of worms, because then everything we've done essentially with that $170,000 is toast.
Oh, because you know what that entails. There's
Yeah, the
1 water
15
line,
foot
1 sewer line.
rear setbacks, et cetera, et cetera, et cetera, unless you do, quote unquote, a variance.
A variance.
Right, and here we are, you know, again and again and again. Can't move forward.
Well, I guess, you know, adding on to that is that you're here for a variance. And obviously, not everybody thinks there should be 2 houses on the same property. But there are ways that other people in town have managed that, but they gave up a rental license. So they only had 1 rental license, and then they were able to. So if we were going to do something like that, we could give you a variance to do that. But that's, you know, but that's your choice. That's your choice of what you want, and that's, I
Well,
think,
there's
what
no
Mr.
guarantee that'll
Townsend-
happen either, you know.
Pardon?
There's no guarantee that I can get a variance for that either. This has been always a moving pile of rocks, I guess, whatever you want to call it, from the onset. Matt and Corey now, I think, are the 4th, if not 5th, set of building inspectors that we've had to deal with. And every time we've approached the city building inspector, it's been total different decisions. One not related to the other at all. It is beyond frustrating.
May I ask you a question, sir? The new home you're building is only 1,600 and some square feet, so I assume it's just 3-bedroom? So you're really not adding to the density of the neighborhood very much by building this new house?
No, we're within
Right.
all the requirements of
Right.
the amount of square footage,
was it
3,000
1800?
square foot that
I
we
thought it
do.
was 18 something.
I know,
18
but I
something,
think
yeah,
the point
similar.
is the same, just for the record. It was 18.5 or something.
Well,
It's less than 2,000.
Yeah,
Well,
it's
to go on my question, wait a
1880.
minute.
Okay, I'll
Let
do
me
one.
go on with my question, though.
It's 1880.
Okay, thanks.
I'm losing my point. My question is, you could tear the whole thing down and build a 3,000 square foot house, and we'd be at the same place density-wise, correct?
Yes. You
So
can
that's
only
the
build
argument
3,000 square
I'm making
foot.
for you, if you will.
You can only build 3,000 square foot of livable space in the city on a 5,000 square foot lot.
He's
Margaret?
not asking for additional lot coverage or FAR or
That was
anything.
I
Just
sort of
to
knew
be
the
code-
answer, but I wanted to
Just to
ask
be
you to
code
make the
compliant,
point.
all I'm asking.
Right. I have no further questions.
So, Mr. Mickelson, I'm sorry to keep you there. So when I'm going back to what Fred asked you, when you look at, you've heard us say exceptional practical difficulty, or you've heard several of them. You may know that that's a quick check factor that we have to consider as one of the driving forces of granting or not granting a variance. And what Fred was asking were, what are the things that are just so difficult for you that you would call them your exceptional practical difficulties if we did not grant the variance? I think that might be where some or all of us here at the board is trying to figure out if we have that. I'm sorry.
Mold and water, incursion into the house, through our lot, we're trying to remedy a problem that we inherited. So,
If I could can I ask him a question?
I don't know.
Yeah.
I mean, it may take some time to build this house, and the other one's going to be demolished. Have you stayed in the cottage yourself?
yes,
So you could stay there as an option
Yes.
while the house is being built if it took a year or two?
that would be our intent.
Must be a dwelling.
What is a dwelling? But it's not a garage, it's.
I'm
yeah,
pulling your leg a little bit.
I know.
Well, just following up on Edie's question, the standard that you have to show is if the restriction, and the restriction here is more than one dwelling on the lot, is not removed, that restriction would create exceptional practical difficulty for the owner in relation to his efforts to make normal improvements in the character of the use of the property. And that's, I think, where we're all struggling.
Yes, that's where I'm struggling.
Because what you're really saying is, if you don't remove that restriction, I will lose the grandfathered benefit I have of being able to have two structures on the property, which you can't now do. Because it's 1991 was a limitation. And I think where we're all struggling is finding that to be the exceptional practical difficulty. Because you can have, as Mark said, a 3,000 square foot house, 60% coverage and 5,000 square foot lot. You would give up the grandfathered 1959 structure. And the question is being required to give that up, because nobody's saying you can't improve the house. Nobody's saying you shouldn't be able to avoid the water damage. And we've lived with that. You don't want that, obviously. But I think the issue that I see for the board is losing the second structure, which is grandfathered but not allowed anymore, an exceptional practical difficulty under quick check. Does that make sense to people?
Well, and I appreciate the way you're framing it. I think you got to focus on the exceptional, right? They didn't necessarily want to build another primary residence. They more or less have to. And I think Mr. Townsend's question say, well, you're going to build it, or do you have to? It seems like that's kind of exceptional. Not everybody has to build a new home because of water damage, right? Is it a hardship for them not to be able to improve their assets, maintain their assets, which they've done they've living on the property over 10 years? I think it is, a difficulty, and it's exceptional not to be able to do that. In fact, take it away. Is that a difficulty? Ask anybody about that. I think it is. Is this a unique kind of case? Yeah, it is, because of the water damage, because of the history of the property. I think because of, as you pointed out, the language of garage apartment is ambiguous, although some disagree. So they're in a tough spot. And for you all to say, and I get it, because you're really thoughtful, very thoughtful, is, well, wait, is the law, and is the purpose of this code scheme for attrition of these things? Not in this case. I don't think not in this case. And you can disagree, but that's the argument. I think it is exceptional, and it does affect them practically. You can diminish it, or you could say, yeah, it's a real thing. They're making an effort to improve the property. And really, it comes down to that.
I have one other question for Mr. Mickelson that just occurred to me. In 2016-17, when you were so deeply involved in remodeling or redoing the cottage apartment, what did you think was going to happen in the future? What was your view? Because I imagine you were looking at this older house and thinking something. So what were you thinking as you and your wife looked at doing that one and then
We had hopes of moving right ahead,
to the cottage
the main
apartment?
house, after the cottage house was completed. And, we were looking at other homes in our neighborhood that were able to do that. But the way the city building inspectors apply that 50% rule and all the other issues that we have changed. 1 time, 2 times, 3 times, 4 times. We couldn't get past the hump.
So you
We couldn't
applied,
get,
you applied to make changes to what I'll call it the main house
No,
back in 2017 after you finished the cottage, or
no,
what happened?
We met with the building inspectors
Oh, I see what you're saying.
multiple times, had them out to our property. We've even had Matt and Corey out to our property 3, 4 times. I guess Corey newer, he hasn't been out as much as Matt. But every time we talked to him, there was a totally different interpretation of what the code says here in Rehoboth. 5 times.
So did you feel there was an implied promise or an implied consideration of that
No, there's
if
just no way to ever go forward. There was never a way to go forward.
Mhm.
That's how when they came to meet with me, we ended up moving
Thank you, sir.
from, I came and met with Corey and Matt and discussed, their hope had been that once they finished the guest cottage and they had that as a habitable space for themselves, they would then be able to move into renovating the front house.
That's what I was.
Not
that's what I was trying to
being
get at.
aware of the fact that they were going to run into this greater than 50%. So,
So you've been working on this idea since 2017?
they had their initial meetings. They never, we never met until but they had initial thoughts and initial conversations going back that far.
So
The city,
you were,
yes.
you were
With the city.
you were piggybacking essentially. You had the idea, we'll do this, and then we'll do that. And you did one, and then you thought you were moving forward.
He wasn't there on the first one.
But that was not a new house. She's asking,
I'm
she's
asking Mr.
speaking
Mickelson.
directly
Oh,
to
okay.
Yes,
him.
Mr. Mickelson.
And so then the challenge became because, the exceptional practical difficulty here is created by 1959 in 1991, in my opinion. If you want something to hang your hat on, that's what you hang it on. That's the exceptional practical difficulty.
In what way? How do you just?
In the fact that you allowed these dwellings to be grandfathered, and then if somebody were to wait until they have to do 50% improvement to the property, and we're not talking about he was going to expand at 50%, that because the square footage, there was a calculation that was done by Mr. Mickelson and his draftsman in cooperation with the building officials, that they came up to this formula that said, you're exceeding 50% improvement on the property, you can't improve it. Now, really, that is an exceptional practical difficulty if there ever was, right? That's like, gotcha, you now only want to renovate your existing house that you have on the property, because that's where the Mickelsons started, and we talk about that in our narrative. But when I then talked with some previous council and some other heads throughout the city, that's when we came to the idea of, let's make it fully zoning compliant. That should make more sense. Not the dwelling unit, but all the other facets of the house. Because if we can't do this 50%, improvement. And I mean, I would venture to say that if you were to say today to the Mickelsons, okay, we'll grant you a variance on the 50% improvement rule, they would walk out of here and feel relieved. But that's not where we went to with this, because it just seemed like getting the building elevated. I mean, there's a lot of practical difficulties to being able to renovate this property and not have it still be a flood zone. I mean, it will be a flood zone no matter what, because you'd have to have one portion of the house that's down lower. Yes, you could go back inside of the setback and elevate the rest of the house. So that's why we came back to, I mean, I'm not kidding when I say the exceptional practical difficulty is 1959. And the fact that in 1991, the city told however many people they told, Corey probably knows the number because he's had to deal with this enough already. And yes, I agree, Mrs. Kunisey, that there are some people who have abandoned. I'm doing a job at 12 Pennsylvania Avenue. The client got rid of their second dwelling unit. But that's because they didn't want to have the option of having friends and family live in a second dwelling unit on the property, or occasionally getting some. But that's a decision that they made. It's not an exceptional practical difficulty that was meted out on them by the city by saying, you have this property and we're taking it away from you. I really think that 1959 created in 1991, and if we went back and looked at the minutes, which I think would be a great exercise for everybody.
Connie, aren't we going around in a circle here quite a bit?
Yes, and I didn't want to interrupt, but I just want to ask the Mickelsons one more time.
I don't want to interrupt you, but we were going into the perimeter of
There are
everything.
many people in this community who have the same situation with you, living in an R1 neighborhood with 2 rental licenses, and then wanting to tear down or replace one of the houses. When that happens, the structure that's left on the site becomes the main house. It can be the cottage, or in the case of, I know the people at 12, it can be the case of something rear, of a rear. But whatever. They made a decision, that they would rather, the city said, okay, well, you can build forward. You might be 4 feet and 4 feet on the accessory building, but the rest of it will be in compliance. You just put a hallway up and you connect them, whatever. It was important enough to the city that they remove the multiple rental licenses from R1 districts. And those decisions have been held up in court. And I can go back, I wrote all the numbers down, but 270-20. Anyway, the years, it goes to 2001, 2010, 2015 or 16. The people in Rehoboth voted by referendum in either 2005 and 2006, I forget which year, to limit 3,000 square feet on a piece of property. So it's not I don't see an exceptional practical difficulty, I'll be honest with you, but I'm asking you, if we could do something today, would you be willing to do something? If you don't want to, if that's not what you want to do, then that's your choice.
Well, had I not run into the flooding and mold issue, okay, I would have just rebuilt the existing cottage house. Okay? And here I am again, arguing the same issue for the main house. Because of my flooding, mold issues, I can't solve my problem using the city's code. Why should I be penalized because I didn't create the flooding problem?
So just, we really don't have total flexibility to design some kind of alternate solution from what the applicant is requesting. There were notices that were sent out, there are postings, there are all these applications and everything. So we're here at this point, on the question of whether the applicant has met their obligation to demonstrate an exceptional practical difficulty. And that's what you're going to be deciding.
We discussing amongst ourselves now, we closed.
Is anyone, we heard from Mrs. Fry already about her support. Mr. Fry, do you have anything you want to add? Am I saying that name right?
Yeah, but he talked.
I know, he did on the appeal.
Oh, okay, I'm
Okay.
sorry, I'm sorry.
On the appeal. All right, I think we've worn out the rest of the audience, but the testimony that we had was in support.
She has.
I'd just like to say one thing about the comments about the outside.
Why don't you go to the microphone?
One comment about, saying that you're going to have so many people with apartment garages, you'll have this issue on and on. I'd like to, we have next door to us, a garage that was renovated recently, and it will never become an apartment because in 1959, the family reported that they had electricity in it. Part of that ordinance that they did at that time, if you had water and electricity in a garage apartment or outside structure, you could potentially turn that into an apartment. If you did not have water already, then you would never have that be an apartment. So a lot, and it's, again, in the garage next door to us, they renovated it for strictly storage because it did not have water, and it'll never become a garage apartment. So I don't know whether obviously the city keeps track of those, who's grandfathered in for water and power. So there had to have been, a recognition that those were going to become, apartments where, actually people could have people living there. Then there's the other half of the people that are strictly storage. So, I think there was a recognition from that time that there would be these type of apartments in existence. And they certainly, with their, when they renovated their garage, it already had the water and all. And so it was a legitimate renovation.
So we understand
Yeah,
that.
it was but, again, I don't think you can take away, an asset that somebody has. That's my feeling. So I support what they want to do.
Thank you. Did you have something more?
Yeah, more of a question maybe. The 270-74 has various sections for special exceptions or variances where it defines how you, and Section D is creating a non-conforming use to another non-conforming to another non-conforming. Has that ever been used? I mean, if this, and the sympathies might be not there and the law might not be there, but I just focused on that as I was preparing and thought,
So the one about increasing a nonconformity?
So,
just changing the
so the Board of
non-conforming.
Adjustment is authorized to, in the fourth instance, to authorize changes from one non-conforming use to another non-conforming use. Now, I think we're probably talking about residential uses in all cases, in this
I
instance.
don't want to take more of your time. It just seemed like this is a unique case, and if you're hung up on the practical difficulty, you're hung up on it. But I didn't know if that was because of the water damage, which it seems like the board has recognized that as real. It's real to them, and it's real, and you found that. And, we're not necessarily going to appeal this, but you think about what's that look like if they couldn't do this and they took away something because they're suffering from, a visitation from Providence of, the water damage, or a neighbor that caused the water. And that's why I think, me, Randy, are vehement about trying to help these people and look for every avenue.
I don't know if the city has any comments to make on 74D.
One comment, we're talking about this mold, and you see all these articles about black mold and people dying from it and all that sort of stuff. So if they were to be, the house were to be condemned, if this were black mold, what do? They say, tough luck. You got to either live there and die, or you can take it down and rebuild. Common sense is involved in this, in my thought process. Thank you.
Thank you. Anything from the city on 74D?
Not really, just highlighting 270-48, changing classification of non-conforming use. Just wanted to highlight that. Non-conforming use of a structure may be changed to another non-conforming use. And it goes on. I can read it if it'd be helpful, but.
But isn't that dealing with like a commercial use or a conditional use or something that is not permitted in a residential zone or something that pre-existed that would not be permitted any longer?
Yeah, if I may, that's more in lines with classes of occupancy, types of, if it's assembly, commercial use, residential, or types of those types of uses. All of these are going to be accessory, non-dwelling, or single-family dwelling uses.
So they're residential uses? I mean, in this.
Correct.
In this case?
Correct. I see no change of use on this property.
Thanks.
But isn't the nonconformity the issue? I mean, if D says.
Nonconformity is an issue, but this particular provision is referring to a nonconforming use, not a nonconforming structure.
What Mr. Willard mentioned.
And quite frankly, I didn't mean to get you all sidetracked on that. You know, as we go forward with this, we'll see where we go. But I just didn't know if it had ever been used for exceptional difficulties that are really unique, because they're really forced to have to build a new primary dwelling, so. But I think we've made our case for exceptional practical difficulty.
Yeah, but I know I'm repeating myself, Fred, but I want to make sure I understand. Do we agree that the restriction that we're referring to here is the provision that says that there cannot be more than one dwelling on a 5,000 square foot lot?
That's right.
Because he's in code with everything else.
Yeah, but I'm saying that, you know, just going back to a quick check, it says, you know, whether if the restriction is not removed, the restriction would create exceptional practical difficulties. So the restriction here is the requirement, the limitation of one dwelling on the lot. And they have and what they're asking is to be able to have two dwellings on the lot. Isn't that really what what we're talking about?
Rental licenses.
Which is what they have.
Yes, I understand that.
Right.
Yeah, 2 certificates of occupancy, 2 rental licenses.
Is it one certificate of occupancy?
No, I think it's 2.
This would be 2. It would be seen as a detached, single-family
Okay.
dwelling.
Yeah,
All right.
it would be
Okay.
2. Unless you,
Are we closed to the public now?
Does
that we can
anybody
discuss it?
want to make any more comments? Anything? Okay, then the hearing is closed. Okay,
I didn't know if we should talk about it amongst ourselves yet or not.
yes, we can. Now we can do that.
I think the case was made for a variance because there is extreme difficulty having to do mostly with the water, and the fact that the property needs to be repaired, replaced, and that because of the circumstances, the second building is a considerable investment, and I do think there would be a substantial loss if that had to be torn down.
Well, I don't think it has to be. I disagree. And I'm sure you know, I mean, I think that they don't have an exceptional practical difficulty. Sorry, they don't have an exceptional practical difficulty. They have options, and they choose not to exercise those options. And that's my.
What are the options?
Well, they could have one structure. You know, they don't want to give up their rental license. I mean, that's, to me, exactly where they are right now, because I think we could either extend a hearing or post something new and try to work with them to have one structure. But that's not what.
But why
that's
is
not what the
one
Memphis
structure better than 2 smaller structures?
Because, first of all, it's code. It's code. It's been held up in court. It's been, the city passed this in 2001. There was a referendum in 2006.
So we're not saying that the code allows this. We're not saying the code allows, we've specifically said the code doesn't allow having two
Right,
dwellings.
exactly.
Doesn't allow having 2 dwellings. So we're beyond that point. The question is, do we, which we often or sometimes do, relax the strict enforcement of the code under certain circumstances. And why not in this case if we're not inclined to do it? That's all. Just why not in this case? That's your charge. To support why it is that an exceptional practical, if you're inclined to vote no, then what aspects of the quick check test has the applicant failed to meet?
I'd like to know what Edie's thinking and Bill's thinking.
Yeah, look, these are all tough.
Very.
Yeah, I'm leaning towards where Mark is, and and where I was going is I don't think we should be telling people to make much bigger houses. I don't understand that. That's frank. A, it's not our job, and B, I don't think it's where the city is at all. What we end up with here is allowing the existing 1959 structure to remain and allowing a new structure that is totally code compliant, which means if you look at the existing map, the new structure is code compliant.
But it's not a 1959 structure. The rear cottage was just redone in 2017.
No, but I'm saying, but it's allowed by 1959.
This section of the code.
It was then, but if you take it down, then it's not. And after the meeting, I'll tell you why they put that in 1991.
I'm just stuck with what the law says, Jen, not what you understand was the motivations for it. Where I am is you've got the board allowed the improvements to the second structure 6 years ago. What we have now is that structure and a frankly not habitable existing structure that it is itself not code compliant. The proposal is to take that main structure, make it code compliant, move it so it's not, at this point it's 3.5 feet on the east side, I believe. So it will be code compliant. It will not flood. That's all to the improvement for everybody. And I understand, which is why I asked the question as to what happened 7 years ago. I understand the risk that we run of people gaming the system, frankly, which is intentionally fixing up the older structures and then coming in here and saying a couple of years later, I spent all that money.
Oh, we have to do it.
And I understand that, and I understand that is a risk. That's a risk, and and we or our successors will have to make the judgment every time about whether we think somebody's gaming it or not. I think we're all familiar with the fact that when it rains in this town, too much of it stays on the streets, which is a really big problem. So where I am, and I agree it's not easy, is that granting a variance on the restriction to allow them to make the improvements without having to tear down the secondary structure does meet the exceptional practical difficulty, and I believe is consistent with what the city generally is trying to do, which is that the new construction be code compliant, so that they're not asking for a variance on anything other than having to tear down the recently rebuilt structure. If I felt that it had been gamed, I'd feel differently. If I thought that it was somehow that somebody just simply wanted a nicer place, that's one thing. But looking to see what's happening, I'm personally convinced that that's not what's going on here. But I do recognize what the concerns would be with people gaming the system.
Well, I'm kind of in a ditto bucket with Bill. I think this is very, very difficult because we know that the city wants to discourage density. We know that the city grandfathers things, but doesn't expect, as I said, for it to go on forever and ever and ever and ever. That, as Jan said very well, there's an evolution, and over time, there are corrections. I understand the, as you said, the unrelated building inspectors and options over the years. I'm sure that that has happened. And I, too, don't think we're being gamed here. And we have been gamed before, by the way, folks. And there's a reason we're a little battle shocked here, because we have. But I don't feel that that's happening at all in this case. I think the water is atrocious. The water situation for these poor folks and all of their neighbors is just horrible. We can't solve the water problem, unfortunately. We're not dealing with that today. But to me, the water alone could be an exceptional practical difficulty for that lot. But I'm bothered by the two dwellings, because I really do think that there are two dwellings on that lot, as the city defines dwellings. That's kind of where I am, guys.
Well, does somebody want to make a motion?
Yeah, I'll make a motion to grant the variance as requested. You want me to lay out the reasons, Fred, or should I wait for a second?
You can rely on the reasons that you just gave.
Okay, I will rely on the reasons that I just stated.
Is there a second?
I'll second it. I'm relying on the same reasons Bill just gave.
All right. So where should we start? Start up with you, Bill, this time.
Yeah, all right. I will support the motion I made for the reasons I stated. I believe it meets all the quick check factors, and I believe that they've demonstrated exceptional practical difficulty.
Mark?
I also would vote in favor of the motion. I do think that the exceptional difficulty has been met, particularly with the degree of flooding that they've experienced and are likely to continue to experience.
Edie?
I, too, will support the motion. With some trepidation, but I still will support it. I mean, it's right or left, so I'm going there. I guess I don't feel there's one overriding exceptional practical difficulty. I feel that there's a menu of practical difficulties which gathered together gives me the exceptional practical difficulty. Frequently, we're looking for one, or a real decision point, and I don't have any of these that say absolutely no way or yes. But the combination, I guess that's a good way to say it, of the water and the number of years and of frustration and the money put into the cottage, and some of the other points that have been made so well by my co-commissioners here, I will support.
And of course, I will say no. I don't believe there's exceptional practical difficulties. I believe that there are adjustments and things that the owners could have made, and they chose not to do that. And so I can't vote for this. So, but the motion passes 3-1. You didn't need my vote anyway. Is there any other business?
I think, do we have? Yeah, so the variance is granted, so that matter is concluded. We don't have anything else on the agenda. I think you all are free to go. I think there's some desire on the board to have a discussion, and it might involve Ms. Womack a little bit in terms of how realistic it is to expect that materials could be provided any earlier to the board than they are, what the practical considerations are, and what options might the board have in the event that we have a very complicated record to consider we never know how complicated these applications are going to be. They might look pretty simple to us and generate hours of deliberations like what happened tonight. But then sometimes we do receive a lot of documents which could be time-consuming to get command of. So
I guess, Ann, what we were thinking about, Ann, was I know the Planning Commission gets their documents 3 weeks in advance. Well, I have a copy of their bylaws, and I talked to several people, and they said they do. They don't get the building inspector's report, but they get, when they're doing a site plan review, and they're doing they get their documents 3 weeks in advance, and we don't need them 3 weeks in advance because we're not doing site plan review.
When they originally come in for site plan review, they go to the chair and also to the attorney of the
Right, but they get distributed to all the,
distribute them to the entire planning commission.
well, the chair does, and the attorney does. So the whole Planning Commission has them 3 weeks. It's in their bylaws
is that
beforehand.
right? It's in their bylaws?
Yeah, I sent you the bylaws. I sent you the link for them. And it is in there, yeah, it's in their bylaws.
Okay.
And that's why, you know,
So and that specific to the application, not to any other documents that get created later on? Is that
it's
right?
not, you can,
It's not the entirety of what comes to the Planning Commission or what might come to us. It's just the application materials? Is that right?
no, it's all the documents.
All the documents?
It's whatever is submitted, I send to the chair and to the attorney.
They have to have them 3 weeks in
Does,
advance.
does the building inspector write a report on Planning Commission matters?
Yes.
For certain
They
matters,
do.
yeah.
But your documents, what I was told was the building inspector's report isn't in 3 weeks in advance. It still comes in a week in advance. Was that correct?
Are we talking for the Planning Commission?
Planning Commission, yes.
2 weeks,
It comes in 2 weeks in advance for the Planning Commission?
generally.
Okay. And we've had a couple of cases recently where we didn't get the documents in a timely manner. And,
What do you consider not timely?
well, it was shorter than a week before the meeting. And in fact, one meeting,
Recently?
no, I'm talking one meeting, and I think it was their first meeting. We didn't get any documents hardly at all, and Matt didn't have any documents. And we had to listen to people making up stuff, and we had no proof, we had no surveys, we had no anything. And we've had a couple of hotels, and they've been lengthy, the documents. I mean, books. And it would be nice to get them 2 weeks in advance. If somebody wants to change a roof line, that goes into the setback because they have water, we don't need something like that. But we do need for more complex, and I understand, at least from the Planning Commission, that it looks like we might get a hotel for a variance in March. I don't know if that's accurate or not.
So one of my reactions to it is that while the board should endeavor to decide cases the day that they're heard, it would not be inappropriate in extreme cases where you felt like you were not prepared to make a thoughtful decision, given the size of the record, that you could defer action until the next month. So you have the public hearing, and then you could decide whether to adjourn with the public hearing open to allow for additional back and forth with the applicant. But all that the more you do in that regard, the messier it gets.
Yeah, the problem there is people bring lawyers in, for some of the hotels they brought in, consultants from out of town. I don't think that, and none of us wants to be.
And that invites people to try and influence the members between meetings.
Yeah, but
we
it's all.
We want to minimize that.
And look, this is a very thoughtful board, and people do their homework, and we don't want to be up there where we're either afterwards say, "Gee, I wish I'd had more time to read it so I could ask the guy another question," or you ask something and it's, and you sound silly because you haven't had time to prepare. And last time I checked, most of us have other things we're doing other than this. So, I think what the frustration is, if you get the stuff, even a week in advance and you have a busy week with everything else, you're not,
This last group took a lot of
yeah,
time to go all through this,
right.
over and over.
So I think, part of the question then is whether, even getting, if you know that, for example, there's a hotel coming in, even getting this stuff piecemeal saying,
She's got to keep track of what she said.
I know that, but at least, if she's not getting, if people are allowed to send stuff to her up to a week before, if that's what's allowed,
Yeah.
They're not going to do it.
then a lot of people are going to do that. And then, by the time she's got it ready, then we're getting a week or less. If, for example, if there is a hotel coming up the end of March and she starts getting a bunch of stuff in that looks like it's lengthy, I would rather get it marked, this is preliminary, but get it, 3 weeks in advance, knowing that I may have to go back over it a little bit, but at least I've had one read through. And then I get Corey's report, then I maybe get the legal stuff. But if I've read the plans, I've read the history, done some research on the code, the only reason we could survive today is, we're looking at the code and, what sections to look at, because it's, unfortunately, most of these guys don't give us the code sections in a way that's readable, so you got to go back to the
Like
website
1959.
and look at the code, but you don't want to be doing that
Right.
at 4 o'clock in the afternoon when the room is full.
Right.
So I think my request would be, at least if we know we're going to have something that's reasonably complex and you start getting things in advance that are lengthy, I would prefer if you could send it to us saying, this is my first batch. There'll be more to come. And then, and then it's up to us to make sure that we've read through everything when the whole formal package comes. So that at least is my suggestion. I think it's better, Fred, than the idea that we're going to adjourn when somebody's flown somebody in from Chicago.
Right.
And especially on the commercial stuff, that's what they're doing. They're not using only local people.
Right. I don't know about the rest of you, but I can really start focusing, even though I have material to read, I really can start focusing when I have the building inspector's report, because then I realize what the nuts and bolts are to glean out from all the stuff that you've been given, because there are times that a lot of the things that we've been given, even the last couple times, they're not, some of it's superfluous, but you don't know that until you know the nuts and bolts of what the building inspector has said. So I'm not sure, timeline-wise, if we're not getting that, I'm not against what you said, Bill,
understand.
but how does your brain go about it?
Well, ideally, if Corey could plan that that the building inspector's report is done 10 days in advance, it's certainly better for us. I know you guys got lots of things to do, and and we don't want to impose more on it. I guess, short of that, I'd rather, especially if there are going to be lengthy stuff, I'd rather have a chance to be able to look through and then go back. And then if you have the guidepost of Corey's report, then when I've read it a second time, I have a better sense for it.
Don't you take
I
it with you,
agree.
though, when you go and visit the property? I mean, I always take the report with me and try to read while I'm looking at the house and see what they're talking
I
about.
take pictures from the road so I can remember it, and then,
Oh, no, I don't take,
Do we get stalking?
I don't want, I
privileges?
was just saying, I don't want somebody watching me take pictures in front of their house.
maybe we should ask Ann, what makes sense of what we're saying, Ann? Or are we way off the line that sending stuff in pieces or whatever? I'm not trying to diminish anything my learned friends have said, but what makes,
I don't only deal with the Board of Adjustment, I deal with the Planning Commission, I deal with Parks and Shade Tree, and I deal with the mayor and commissioners.
yeah,
And I have hearings with all 4 of you.
yeah.
And if I have to do piecemeal for one, I would have to do piecemeal for all 4. And that is gonna be way too confusing.
Well, I would put it this way then. If we get something from a hotel or some big commercial project the week before the meeting is scheduled, then I don't think we should schedule the meeting for that week. I think we should go out a month and just say, it's impossible, we can't do it, because we cannot read a notebook like this full of stuff and go back and forth with the code and maybe even go measure parking spaces ourselves in a week. It's not possible.
Jan, you used the word commercial, and you're right, that could be the different,
be
that
the
could be the
divider.
border right there, the divider, commercial and residential. The residential we could do as we're doing, and commercial we could put a higher restriction or a higher requirement.
3 weeks trying to determine if the hearing is gonna even take place
Sure.
at the next month.
Right.
So that's a little 3 weeks.
Tough.
I
That's
think,
tough, yeah.
maybe 2, but not 3 weeks, because I also have the public notices to do in that 3-week span. I had the mailings to do in that 3-week span. I had the signage to do in that 3-week span. So y'all are asking for a lot from one person.
And we don't probably know what we're asking.
Yeah.
We probably don't know what
We're
we're
just thinking
asking.
out loud.
Right,
So
so,
this is thinking out loud about an issue maybe.
and I will say that if we can't do it today, and we may not, I don't think I'm going to recommend that we establish some kind of rule that if we violate it, then it just upsets the whole apple cart, and we can't go forward because we have some internal rule with some deadline that is going to send a whole room full of people home. So I think, I don't know, I want to hear from everybody, but, pardon me?
Can you put that in your rules of procedure?
I don't think I would hesitate to do that because I don't want one person who is particularly opposed to something to cite the rule for a reason why we can't go forward. Or 5 people who are particularly opposed to something, if it's not closely tied to the difficulty that the board is going to have in making a good decision.
Yeah, but that would also, raise a question if we adopted a rule that, sort of said what Mark was saying, which is, applicants should be aware that in a complex matter, a matter having substantial, we don't even have to define what the words are, material, they are encouraged, strongly encouraged, to get the materials to the secretary, at least 21 days in advance, whatever, so that at least she'd have a shot at having the material in time so that we had more than a week on the bigger cases. I'd rather do that than, I agree with you, I don't want to give anybody the right to tell us whether we can proceed. But also that if somebody does dump a bunch of stuff on Ann a week before, that if you or Ann has to call them and say, you saw, Rule 7 says, don't do this. There's no emergency. This is not, where FEMA just approved it. FEMA approved this 3 months ago. You had plenty of time. We're going to put it off for a month, and I'm sorry if that's going to delay you, but I've discussed it with the members, and they're not prepared. They can't give this justice.
Right.
But I agree that, I think if we had a rule that said, that, and, then you'd be able to point to it, but it'd be our judgment about whether to go ahead or not.
Okay, well, we can, maybe at the next meeting, I can mock up a rule for us to consider adding to our bylaws, which will give direction to Ann, and will allow for some back and forth with the applicants in advance of the meeting. The applicant does have the burden, and if the applicant's got a complex case and they can't make that case in 2 hours or an hour, then they're the ones who are going to suffer. So they do need to get this information into us, and not at the last minute.
And then, to the extent that Corey and Alex can also say to them, look, by the way, this is on the record, so somebody can look on it if they want to, but say, you should be aware that at the February meeting, the board was, adamant that these big cases, that they get enough time to do it. And so, you've told me you're going to get a variance. Don't think you're going to, be able to put in, on a week's notice, in terms of the materials, something this complex. You've been dealing with me, Corey, Alex for 3 months. Be fair to the Board of Adjustment and give them a little bit of time to be able to absorb it.
Of course, who would have thought we would have spent 2 hours per case today on 2 residential issues, and all of the time we each must have spent to prepare for today.
But that probably was not based, it wasn't based on documents, though, probably. It wasn't,
Well, but you had to know where they were coming. I always have to know. I have to go from the details. I have to know where they're coming from. But
It was a total.
and you do have to know where they're coming from.
Right.
And there's a lot that they don't present in their
Right,
writings that is
right, and-
critical to your
And one of the
process.
key things that Bill was so great about was when you said, I don't feel we're being gamed in this situation.
Well, I think
We're
it's
still
critical,
recording,
because I
so-
know that concerns,
Yeah.
Jan a lot, and she's been around this much longer
Well,
than I
yeah,
have.
and we've all seen
Did you
it.
want to add anything to this?
I would just like to kind of wrap this discussion up. Mary Ellen Gray, Planning Community Development Director, for the record. I think there's some good comments, and I certainly, I would be reticent to put a hard and fast
I'm
due date.
having a hard time understanding you. Could you be?
Excuse me, I would be reticent to put a hard and fast due date. Talking about 3 weeks, I think I echo Ann's concerns regarding timing, because then we're pressed. We have a queue of projects that we review, and we review them in the order in which they come in. And we do the best we can with the resources we have, but I don't want to be put in a position, just as you said, Fred, that we would have to push off an application because we missed a due date to distribute materials to you all. So I think what I'm hearing is that you would like, for complicated projects, you would like the information sooner than later. You can certainly make a commitment to doing that, to trying our best to do that. But also that's gathering information from the application, but then also the hearing. That's what the hearing's for, is to gather more information from the applicant. And certainly, here again, I'm not a lawyer, I'm not telling you what to do, but if you feel you don't have enough information, that's your right to ask for more at the time. So is that's kind of wrapping that all up and sharing my perspective from the staff standpoint. We try the best we can, but we want to keep moving applications along as well.
You know, it's almost what I said to you guys the other day in that email when we were talking about this, because it's procedural, so we can talk about it out ex parte. You almost don't know what you don't know till you don't know it.
That's true.
I mean,
I
so
think
it's
when
a
you
catch-22, because you start reading and all this, and you think, oh my gosh, I gotta really look at this. I gotta go into code more. I've gotta look at these drawings, if they're accurate, when they were this. And all of a sudden you say, wow. And so, and that's, for me, it can be more toward the end of the process, when I find out, boy, I've got to spend a lot more time than I thought to get up to speed for the meeting, and it's within, within a few days, not 2, but maybe 4 or 5 of the meeting, or gee, I've got to speak to Fred about something because I have a question and I don't want to talk to a fellow board member, but I ask Fred, and I don't. It's kind of a slippery slope there.
Yep.
The only other thing we're going to talk about was pick a day for May.
That's right.
And also, the first night of Passover is the day of our whatever meeting. I looked that up today when you said about May, and maybe it's March, or when is Passover?
I don't know.
I'm not sure.
I don't know that answer. Here, I have
Wait a minute.
my phone.
But, and I don't know if it matters, it is the evening, or the day of our meeting, that Monday is the evening it begins Passover, and I know that for Jewish holidays, we've changed our meeting before.
Mm-hmm. Good point.
So, and I don't know if it matters for evening.
So it would be March 25th, says holy, H-O-L-I.
That must be it.
Is that?
H-O-L-I?
Yeah, that's
Sure.
what it
It only has
said.
4 letters.
All right. Well,
22nd, the 22nd of April is Passover.
okay. then
And that's
when
the
it is.
date. That's the date of the.
Of the
right,
April meeting,
Of
yeah.
the April meeting, that's right. So we have to maybe
wanna
look at
change
April
that?
and, I don't know.
To the following, maybe, to the 29th?
Are Tuesdays better for you all than some other days of the week?
I would
No.
defer to, excuse me, I would defer to Ann on that.
Probably no days are good.
No days are good.
Poor Ann.
Well, I know we don't
And we
have.
thought by moving to 1:30, Ann, that you would be gone.
Yeah, really, that was the
Okay,
plan,
well,
wasn't it?
Didn't work,
Yeah.
the very first
How'd that
try.
work?
That was the plan. But if we hadn't, we'd only be halfway through the second meeting, so.
Who would believe that would take that long? I mean, I thought it would be involved, but I didn't think
Yeah.
it'd be an hour and a half to 2 hours
Well,
per.
I don't, you don't have to move April for me, because,
We weren't worried about you, we were worried about them.
It was actually, it was Barry
Yeah, also,
Grant.
you can
Yeah,
find out
so
from
I
Barry.
don't know. Well, I'll send Barry a note.
Okay, well, May, we have to do something because Monday, the 27th is Memorial Day. which is a legal holiday.
Yeah. And we don't
So,
want to
so
be
we
anywhere
have to,
near a
we have
holiday.
to do something. What, Ann, do you have a suggestion in May, since it's,
Typically, what happens in May and December is it's moved a week before.
so like the 20th?
Oh.
Are you-
Okay.
Are you okay with that?
I think
I'm pointing at you.
I think Mondays are generally fine. I don't have conflicts with other town meetings on Mondays.
Okay.
So Monday, the 20th is what
20th?
we've agreed?
Okay.
So you were saying also about April?
Yes.
Y'all can do it on the 29th, the fifth Monday.
Yeah.
If, well,
There's nothing scheduled that day.
okay. Well, Bill said he didn't need a
Yeah,
change,
why
but
don't you check with Barry?
And I'll check with Barry, and I'll let you, I'll CC you, Ann, when I check with Barry, okay?
okay, so we're definitely changing May to the 20th, is that correct?
I think we should change April also, though, because even though it may be accommodating to us, it may not be accommodating to the
Right,
public.
I'm happy,
Well, it's that night that Passover starts, so I don't know about a daytime, I just don't know.
but he's talking about public who might
Right.
want to come to
I
the
know, but I'm
meeting.
saying, but if
Oh,
it's,
oh, oh.
the daytime might not matter, does
No,
the day?
it starts at sunset, but if people are getting together as a family, they're not going to want to be sitting here at 5 o'clock.
Okay, all
That's
right,
what
so
I'm
we
saying,
changed the
exactly.
April meeting
Who wouldn't
to.
want to
And
sit
it's
here
just-
at 5 o'clock?
I mean,
I
it
don't
seems to
understand.
me it's a simple
I'm looking at some
fix.
people who don't want to be
Right,
here.
how about quarter of 6? Who wouldn't want to sit here at quarter of
Maybe we
6?
could get pizza next time.
So we're gonna make-
4:29,
4:29, is that good?
is that good for April, for people?
That's good with you, Ann?
Yeah, it's fine.
Okay.
I mean, we can confirm all this, but this is where we're leaning.
And who's telling Barry this?
I'm going to.
You're
I'm
telling him
going to-
both things?
Yeah, I'm going to tell Barry, yes.
Okay, so April moved to the 29th.
Mm-hmm.
Still 1:30, right?
Mhm.
No change there.
Yep.
And May moved to,
The
April
20th.
moved forward and May moved back.
Mm-hmm.
Got it.
Good deal.
Well, good job, everybody.
Yep.
Thoughtful Dave.
Yeah, I mean. we
All right,
sure-
And
we sure-
I know I won't be here in June, so.
we adjourn?
I know now, yes.
We sure worked
Adjourn.
our,
Motion to adjourn?
I move that we adjourn.